Conversion petition I have filed it, your lordship's direction to
No, the
for
criminal
promote.
appeal 863 by 24
5 32 of 2020. Increase they have been granted filed by OPT chair, for which the petitioner is not respondent is not getting the pension. Lordship should handle it.
The criminal appeal 863 by 24 on. I for bail man.
मतलब इसे criminal appeal of 2020 हो लड़से already completed for life for लड़से 10 year already completed. I pay for final hearing we are received the paper book. Get full.
Petitioner challenging the high handed action of the NHI authority taking position over the land.
OGLS matter में fresh admission and one land exception.
Fresh additional land action.
Coram land acquisition is place admission.
Supplementary list, item number 1.
May please. Item 1, the petitioner is the third round of litigation, your lordship, has paid its amount for he is the equivalent bidder for auction for land, your lordship. It was allotted to him. He paid 25% in the year 2014. In 2019, after this honorable court's intervention, he paid the rest 75%. Since 2019, he has paid, but it has not been allotted in his favor. On the last round of litigation, this honorable court directed to consider page 22 of your lordship kindly say. Yes, that is at page 20. My prayer was to register in my favor. Yes, sir. Third learned counsel for the party, the petitioner has filed the writ petition with the following prayer. The petitioner, the prayer is there, your lordship. Para 4. In the course of hearing, learned counsel appearing for the petitioner states that the petitioner has already made representation before the opposite part number 3 under Annex C as the same may be directed to be disposed of within a stipulated time. Then the next page, your lordship, page 20. They have not communicated to me saying that you have. Yes, I read that. With reference to the subject cited above, I am to say that you had participated in the auction sale plot number so and so on 22/2/2010 and also declared as the highest bidder on offering 63,50,000 and accordingly deposited 25% of the bid price, that is rupees 15,87,500 on the same day. Thereafter, you failed to deposit the remaining 75% of the bid price either within the stipulated period and also in the extended time. Hence, an order was passed to forfeit the earnest money deposited by you and your claim over the said plot. Again, in obedience to the order passed by the Honorable Court, Honorable High Court of Orissa in WPC number 23674 of 2014, it was again decided to allot the same plot as it was vacant. At the time the auction was determined and the same was intimated, you wide this office letter number so and so, you deposited the balance 75 amount of 47 lakh 62,500 by MR number so and so dated 10/12/2019 of the Tahsildar Raulkela. Again, on going through your application dated 8/9/2023, it was found that the time between deposit of the rest amount and the execution of the lease deed is more than 3 years. As there is no clear view regarding lapse of time in execution of the lease deed in OGLS Act 1962. Hence, a clarification from R&DM department was sought wide this office dated 8/11/2023 and 23/7/2024. Till date, no clarification has been received. So, my humble submission is, lordship, they have, upon the intervention by this honorable court, they have accepted my 75% here. Yes, your lordship. Yes, your lordship. This honorable court. The honorable court.
Same price. It is now.
Yes, your lordship.
The phrase option would be added. Now it may they may give
in 2019, this honorable court. And in obedience to that, this honorable court order, I have paid the 75%. I have deposited 75% upon the after the order of this honorable court. Your lordship may kindly call for this WPC 23674 of 2014, your lordship. Yes, your lordship. That was within 3 years, your lordship. No, after that I filed a writ petition. Yes, your lordship. And this, yes, 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 your lordship. That is the order passed by this honorable court. That they have not done. Only the clarification that they require is that because it is more than 3 years. That order I have not annexed. I'll annex. I will get. Yes. No, this is the last order, your lordship. No, before that, in 2019, your lordship, where this honorable court has directed to allot in my favor because the plot is still vacant and they have not put it in the auction, and I was given an opportunity to pay the rest 70. Yes, your lordship. Yes, your lordship. Yes, your lordship. No, I have paid since 2019, your lordship. I have not paid now. I have paid since 6 years. 10, your lordship. And that was allowed in my favor in 2019, reconfirmed by this honorable court.
It appears, my lord, that that order that he is citing of 2019 is quoted in page 6. Is not given the order. My lord.
No, that is the second round of litigation. The first round of litigation has page 6. Yes, your lordship. And they have not considered. They have just said that it is awaiting. May I please page 6, your lordship? I quoted that order of 2019. Learned counsel for the petitioner submitted that the petitioner were the highest bidders and had deposited the earnest money for allotment of the plots. There is a delay on the part of the authorities to take a decision, and they suddenly informed the petitioner to deposit the balance bid amount within a period of 1 month, which is beyond the control of the petitioner. The petitioner are ready and willing to deposit the balance bid, and the plots may be allotted in the favor. Considering the above facts and circumstances, since the present position regarding availability of plots is not clear, we dispose of the writ petition with an observation that in case the petitioner filed application before the ADM, Raulkela opposite partner for allotment of plots in such event, their application shall be considered by the said opposite party subject to availability of plots, and the earnest money so deposited by the petitioner be adjusted towards the consideration amount of the plots to be allotted in their favor in accordance with law. The above exercise shall be completed on production of the certified copy of this order along with the applications over. So after this, your lordship, they have accepted my money. Yes, your lordship, they have accepted. Once they have accepted, your lordship, they cannot reiterate back their. Let the notice be, your lordship, let them take, because annexure 8.
Let them assess the present market value. You take instruction if you are ready to deposit that amount and subject to availability of the land.
May please one thing, your lordship. Their objection at page annexure 8, page 22, they say that because it under OGLS Act 3 years beyond, there is no question of registration of it. Let that be clarified, your lordship. If that thing is done, the question of, because once they have accepted the 75% amount, but they have not done so, they have not returned. They have accepted it as per the. No, your lordship, this honorable court said we consider, and they have accepted, considered, and accepted 75% of my balance amount. May I, sir? That's I will take instruction whether the. Yes, your lordship. Yes. Yes.
date of issuance, regular payment, and key clarification. I think key. Further action. The design council for the state inspection. Concerned department. With a provided clarification. Transport. Party. Indian law. Design council for the issue. Ready and time to market time.
Item 2.
Pursuant to Lordship's direction on 22nd of January to file an affidavit, the petitioner has filed the affidavit. With that,
Please pay the also. 22 or 10.
after it's taken up, this restriction has been filed by the petitioner Mukesh Kumar with a prayer for providing RR and benefit as per the order passed by the Land Claim Commission in civil case number so and so. And as he is entitled for the RR benefit as per the Orissa RR Police 2006. And counsel for the petitioner drew the attention of the scope to Annex 3, which is the letter dated 6/9/19 of the General Manager Messenger area number 2, where the opposite part number has specified the petitioner documents and affidavit. So the Land Counsel for the petition submit that in pursuance of the letter issued by the opposite party number, required documents have submitted, but there is no amendment made in the writ petition. So someone Land Counsel for the submit that intends to file an affidavit that respect that the petitioner has complied the requirement as per Annex 3, and the matter may be taken up next week.
Very definitely.
Affidavit is there. So noting there is a affidavit dated 22nd that I have received the letter dated 6/9/19 from the General Manager Mahanadi Police Limited, Basudhara area, Sundargarh for submission of documents. Immediately thereafter, I have submitted the document, that is 2 copies of the passport size photograph, Aadhaar card for identification, and certificate of educational qualification, and affidavit regarding declaration of further landed property in any place except in village Gopalpur to the General Manager Mahanadi Police Basudhara area. 2019, therefore he has not remembered the date. Therefore, he has supplied the documents.
Yes, now what is your prayer?
My prayer is the commission has decided under Annex 2, the Lordship have a glance to page 28. It has been determined by the commission to provide the page 28 of the brief. The present middle paragraph. In the present case, undisputedly, petition was minor on the cutoff date, that is September 2010. From the high school certificate examination, it appears that the birth is 26/1/1996. Thus, on 26/1/2014, the petition attained majority, and till date, MCL has not provided resettlement habitat for which the petitioner family is yet to displaced from the project affected area. As per paragraph 2C note of the RR Policy 2006, for the purpose of declaration of eligibility of R&R benefit, the list of displaced families will be updated on the first day of January every year, on which physical displacement is scheduled to take place. Thus, petitioner being the major son of the recorded tenant having attained majority in the year 2014 and not being displaced till date from the project area is entitled to get the employment under category 1 and resettlement as separate family. In the result, the prayer of the petitioner to provide the employment under category 1 and resettlement is allowed. Despite that order, the same has not been provided by the MC. That is the complaint with
So the data, in that data annexure C,
Madam.
they have stated that, what will be these
Documents and I have also deposited. And in similar cases, your lordship issued notice. On the other day, 3 cases were listed. One of such case I am over the copy.
dated
19, madam.
thereafter you have not received income.
I have not received any. Samsung is followed in that case. In the first case is Samsung case. Thereafter,
Item 3.
It is similar order and answer pending before the OP number 39. Yes.
Annexure 4 my lord, that's for 33.
Four. Yes. Yes, ma'am. The only institute is the possession of the land of the institute, Mahavir Institute, in the this government land.
Correction. They are exactly contributed to.
Yes.
Item 4.
So my application of section 28 of land action under annexation 2 years.
Section 28A, within how much time are you supposed to file the application?
90 days. Within 90 days of the judgment passed by the LR.
So you have filed it?
Within the time years. Annexure 2 years. Annexure 2.
Earlier orders were passed by this
Yes,
court.
Yes.
That also you have annexed.
It is not present order.
Yeah. Yes. So correction कर दीजिए
Annexure 2 years. With background 3.
ऐसे correction करचेंदी pencil ले correction कर दियो annexure number टा यदि किसी date fit होची correction कर दीजिए है ना ये बात सब देखी इस project पर
4, 5, 6, 7. 4, 5, 6, 7.
हाँ ठीक है खाली annexure number date सब correction करी pencil ले बढ़ाई दें
তাহলে 4, 5, 6, 7 সব জায়গা अलग अलग হবো সেই অনুসারে দেবে
हाँ लिखी देवे item number 4 टा होची यदि annexure 3 item number 5 annexure 5 से टाइप लो लिखी देवे है ना yes
Item 8.
The present application is filed by the petitioner seeking employment under RR policy. Land was acquired in 2011 and 2015, towards which compensation was paid to him.
you have submitted a representation to the collector
All the opposite parties.
and when you
Opposite 5 has to consider the representation of the
opposite party number 5 opposite party number 5 is the chief engineer in charge.
Yes, sir. The project is being headed
No,
by.
it's all right. Have you given any representation?
Yes,
to...
sir.
All right. The annexure 3 which is representation how consider karibe opposite party number 5 है ना time limit दे दो from the date of production.
Option number 3 is MCL, but the option number 5 is making the project. So
All right. Next.
Oblique.
Item 9.
With legal effect. And the petitioner in this set application challenges the action of the opposite parties in not extending the RR benefits in favor of the petitioner and rejecting the representation which was directly considered by the Supreme Court in the earlier application manner. So, Lordship.
When it was directed to be considered.
Lordship, annexure 4 million.
Annexure 4.
Yes, madam.
But it is a single judge order as it appears.
Yes, my lord.
All right. Come to the operative part of the order in page number 26, paragraph 8.
Yes, sir. Considering submission made by the Law and Council for the respective parties on careful examination of the background of the fact of the present case and the further taking into consideration the fact that the limited nature of the prayer, this court deems it proper to dispose of the petition by directing the petitioner to file a fresh representation ventilating his grievances along with the certified copy of this order before the chairman from managing director Mohan Coalfield Limited, Sambalpur, opposite partner 3, and the general manager MCL Open Cast Project Lakhanpur area, Jharsuguda, opposite partner 4, within 2 weeks from today. In the event a such representation is filed within the aforesaid period, the opposite partner 3 and 4 shall do well to consider and dispose of the same in accordance with law and the land of the petitioner under RR policy acquired by the MCL within a period of 2 months from the date of receipt of the representation, and the same shall be considered and disposed of by passing a speaking and reading order within the aforesaid time stipulated.
कौन आला था अपने?
My lord, your lordship, thereafter, my lord, they consider my representation, my lord. Your lordship, can have a glance. For that one, I may draw your lordship's attention to Annex 2, my lord, at page 21, my lord. Your lordship, can have a glance.
So the representation was disposed of
Yes, my
in
lord.
Annexure 5.
Yeah, Annex 5 representation disposed of, my lord.
What has been held?
My lord, before that, I may draw your lordship's attention to Annex 2 at page 21. my lord.
Let a Podisha
Yes, yes, my lord. My lord, under Annex 5, my lord, the operating persons, I may draw your lordship at page 28, my lord. And whereas Subraj Pradhan, the son of Boyra.
Leave that, you come to the next paragraph.
Yes, my lord. And whereas the the land has been purchased after on 11/1 notification under CBA and AD Act 1957 after vesting of the land to the government company, now MCL, by the central government. It is free from all encumbrances and there is no right for any compensation along with other benefits against such purchased land. The purchaser transaction is illegal in the eye of law, hence the petition is not eligible for any other benefits as per the norms of the compensation matter. You will see. Thereafter, after going through the comprehension of the representation of the petitioner, the opposite part of found that there is no merit to consider the case of the petitioner as the petitioner intentionally, knowingly purchased the said land after 11/1 notification under 1957 Act to get the compensation and the other benefits. So the representation of petitioner is very well rejected as there is no merit in this case.
Yes.
Yeah, before that, my lord, the lordship can have a glance at page Annex page 21, Annex 2, my lord. Lordship, the compensation has been granted in favor of the petition, my lord. The lordship can have a glance separate 2, my lord. ଏବଂ ଆପଣଙ୍କ କ୍ଷମତାପ୍ରାପ୍ତ ଅଧିକାରୀ ଆସନ୍ତା 1/12/2020 କିମ୍ବା ନୋଟିସ ପାଇବାରେ 1 ସପ୍ତାହ ନିମ୍ନ ବର୍ଣ୍ଣିତ ସମ୍ପତ୍ତି ଯାହାକି 2013 Act ଅନୁସାରେ କାର୍ଯ୍ୟ କ୍ଷତିପୂରଣ ମୋଟ ଅର୍ଥ 1,86,700 ମାତ୍ର ମହାପ୍ରବନ୍ଧକ ଲଖନପୁର କୋଇଲା କ୍ଷେତ୍ର ବନ୍ଧମାଲ କାର୍ଯ୍ୟାଳୟ ଗ୍ରହଣ କରିନିଅନ୍ତି। ମାନେ they have assessed the compensation that has been paid to the petitioner and deposited in the account of the petitioner. Now they say that I am not entitled for the compensation or the other benefits, my lord, while rejecting my representation, my lord.
No, if you have received the compensation.
My lord, the compensation are assessed and are awarded to me, my lord. And the compensation amount has been deposited in my bank account, my lord. I filed the earlier representation for grant of RR benefits. Simply,
So RR benefit is one thing, but if you have received the compensation,
yes, my lord.
Then what further you want?
My lord, I requested them since the only land, homestead land along with my residential land has been acquired by the authority, my lord. I must be granted with the as per the MCL's rules, I must be granted with given a.
But for that, if you have purchased that land after that 11/1 notification, so they have given you the land cost, but
they have wrongly reflected because my representation will have can have a glance. In the year 1984, my lord.
No, unless you satisfy us that even after somebody purchases the land after 11/1 notification, he is also liable to get the RR benefit. Then your relief cannot be granted.
The assessment was done in the year 2018, my lord. They said that they have acquired the land in the year 1987, but assessment was done in the year 2018, my lord. And 2016, initially by virtue of a agreement, my lord, I acquired some land, and thereafter the entire land was purchased by me in the year 2016, my lord. In the year 2018, my lord, the assessment was done, and I was granted with the compensation, my lord. But subsequently, by rejecting my application, they are not only saying that I am not entitled to compensation, but also the other benefit, even though the compensation has been awarded in my favor.
when that notification was issued?
That is, the notification was issued in the year they are saying that.
No, you have not mentioned in the date chart. You have mentioned from the date when you purchased by the registered sell deed in 2016.
But in page 27, my lord, Annex 5, my lord, they stated that they include areas such and such. By notification number 130 dated 16 January 1982. They're saying that in the year 1992, there is a notification and there are 7-1 notification in the 1985, my lord, and 9-1 notification on April 1987. And the vesting was section 11.2 in the 15 December 1988, my lord. But prior to that, by a sale agreement of the year 1884,
Let's see that act, 1957 act.
coal bearing, that's the coal bearing area acquisition and development act 1957.
Coal bearing,
areas
yes.
acquisition and development act 1957.
Giving that notification.
Okay. That was not available to in the regular pickup system, so I was not consulting also. In that receipt also that notification was not annexed and that is in my lord.
That's why the list करना.
କାରଣ ଏଠି ଯୋଉ ପାରାଗ୍ରାଫ ପେଜ ନମ୍ବର 27 ରେ ଆନେକ୍ସର 5 ରେ ଯୋଉ ସେକେଣ୍ଡ ସବ୍ ପାରାଗ୍ରାଫ ରେ ଲେଖା ହେଇଛି ଯୋଉଟା so notified and vested under so and so act ଏଟା ହେଲା notification ହଉଛି 16 January 1982 ହେଲା
And
then another notification was made 9-1 notification of that.
in the April 1982.
Then the vesting was made on 11-1, that is on 15th December 1988.
And thereafter, the area was assessed, has been assessed and awarded under the CPA AD Act 19 on 20th November 2018. They assessed the compensation and awarded amazing paid in the year 2018. The last line.
So by that time you had already purchased the
Yes,
land.
purchased land, dictated the same and in the by way Bharbadi Miller.
So fine. So is it your submission that even if the notification under section 4.1, 7.1 and 9.1
Yes, sir.
has already been made,
But assessment was done.
but since the assessment was made in 2018,
As for in 2013 Act.
2013,
Yes, sir.
then
Once
whosoever is the owner by
Yes.
that time
Yes, that
is entitled to get the RR benefit.
RR benefit.
That is your submission.
Yes, ma'am. That is.
What do you say, Mr.?
That is the MCL is the order of that order of the general manager. Lakshmipura MCL. So MCL council is not there. General council is there.
RR benefit କୋଉଠି provision ଅଛି ଦେଖି ଯଦି award ଯଦି ହେଇନଥିବ
Well, they have in page 28 also they have specifically stated, my lord, that somebody has been assessed and awarded under CPA AD 19 order dated 20th November 2000 as per the provision of the right to fair compensation and transference of land acquisition RR Act 2013.
yes ଠିକ ଅଛି ଦେଖ RR benefit ରେ ଦେଖନ୍ତୁ ଯେ ଆପଣଙ୍କର
And since that is the only considered land for that within manner that has been acquired and
କୋଉଠି 2013 କଥା କୋଉଠି ଲେଖା ହେଇଛି
at page 28 madam.
2840
That's the third line madam. Third line has been assessed and awarded under CPA ADR 1950 on the date 20th November 2000 as per RFCPLR RF Act 2013. That is the right to fair compensation.
This writ petition has been filed by the petitioner S.K.Sahoo with a prayer to pass the order dated 11/9/2023 passed by the General Manager Mahanadi Coalfield, bracket opposite party number 4, wherein it was held that as the petitioner intentionally or knowingly purchased the land after section 11(1) notification under the coal bearing areas bracket acquisition and development bracket Act 1957. Gate compensation and RR benefit. There is no merit in the prayer. The land counsel for the petitioner invited this court to annexure number 2, which was issued to the petitioner, wherein on date
23/11/2021. That is on the top of the PR number
23/11/2020. receive the compensation amount of rupees 1,86,733. Which you have already received,
Yes, sir. That has been deposited in my account.
which has already been deposited in the account of the petition. The land and counsel for the petitioner submitted that in the interim order, it is mentioned that even though one notification was made on 16th January 1982, 7-1 notification was made on 15th January 1985, 9-1 notification was made on 29th April 1987, and 11-1 notification was made on 15th December 1988. But the award was made on 20th November 2018. And and the same was as for the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. And since it is not in dispute that the petitioner purchased the land, land
2016, madam. Yes, madam. That is
petitioner purchased the land on 22/8/2016 by way of a registered sale deed. Therefore, he is entitled to get the RR benefits under 2013 Act. And the rejection order passed by the opposite party number 4 is not sustainable in the eye of law. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission when counsel for the state accept notice on behalf of opposite party number state during course of this week. So far as opposite party number 3 to 8 are concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter will be listed after 4 weeks. Counter affidavit, if any, will be filed in the meantime.
I mean, I filed an application. They are taking steps directly from the land.
So, interim application issue notice कर दो accept one set of process fee. The after land but fix it. Yeah. Then
Item 10.
Make legal effect. While the petition in this state application challenges the notice issued under Annex 11 to exit the petition from the land. So the area extent of the area under acquisition is subject to reconsideration by the opposite party. Pursuant to direction of the Honorable Court, my lord. You will see the petition on the land in question which is acquired by the for Talcher Bimolgarh NGB rail project link project, my lord. that is the ancestral property, and the area which was acquired, my lord, that fall to the share of the petitioner by way of mutual agreement, my lord. And thereafter, my lord, while the petitioner residing there, my lord, by constructing one RCC building and one team rooted building along with the boundary wall, my lord, the land acquisition authority decided to take only the land, a team roof building, team roof house, omitting the RCC building, my lord. The grievance of the petitioner was that either you take the entire area with the entire house, my RCC building, and my team rooted building with boundary and everything, my lord, or you divert the same. Thereafter, my lord, and under Annex 8, my lord, my representation was there, my lord, and this honorable court had earlier order dated under Annexure
9. Annexure 9 the disposal of your representation.
Yes, my lord. And your lordship can have a glance to page 50, my lord. That is Annexure 10. That is the order passed by the office, my lord.
Yes.
The relevant process of
Place it.
the case record is put up today. This case has been instituted in compliance to the order dated 25/5/2024 passed by the Honorable High Court of Orissa in WPC number 42220/2023 by the Rudanda Biswal, Janaki Biswal, son of such and such of this to consider the representation filed by the petitioner by the Annexure 8 series in respect of the land acquired for construction of Talche Bimodgar new GB rail link project. The Honorable High Court have passed order in the aforesaid writ petition as agreed by the learned counsel for the parties, and after going through the records, this court, without expressing any opinion on the merit of the case, dispose of the writ petition directing the opposite part of court to consider and dispose of the representation filed by the petitioner by Annex 8 series and pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. On perusal of the representation filed by the petitioner and hearing their grievances and discussing at length the issue concerning them, it was concluded that the East Coast Railway is the apt authority to take a decision in favor of the petitioner in this regard. Hence, by letter number 305 dated 7/8/2024, the Deputy Chief Engineer Construction to East Coast Railway Hon'Ble has been apprised to the case and subsequently requested to take necessary steps and decision in favor of the petitioner at the earliest manner. While this matter was under active consideration by the said authority, my lord, you will also kind of a glance to page 52 Annexure 11, my lord. The notice has been issued by the opposite party number 4, my lord. Safara 2, my lord. ନିମ୍ନ ସ୍ୱାକ୍ଷରିକାରୀଙ୍କ ଦୃଷ୍ଟିକୁ ଅଣାଯାଇଛି ଏବଂ ଘଟଣା ଦୃଷ୍ଟାନ୍ତମାନ ଦୃଷ୍ଟିକୁ ଆସିଛି ଯେ ଆପଣଙ୍କ ଉପର ଜମିକୁ ଅନଧିକାର ପ୍ରବେଶ କରି ଏକ ପକ୍କା ଘର, ପାଚେରୀ ଓ ବୋରୱେଲ କରିଛନ୍ତି. Your lordship, that was the subject matter of dispute in the earlier application, and that was the subject matter of consideration by the opposite party under Annex 8 series. ନିର୍ଦ୍ଦେଶ କ୍ରମେ ସମ୍ପୃକ୍ତ ସମସ୍ତ ଅନୁରୋଧ କରୁଛନ୍ତି ଆଗାମୀ 25/2024 ସୁଦ୍ଧା ଉପରୋକ୍ତ ପ୍ଲଟକୁ ସ୍ୱଇଚ୍ଛାରେ ଖାଲି
No, if you the authority has stated while adjudicating that Annexure 10 passing,
yes, ma'am.
that the East Coast Railway is the authority who can take a decision
Yes, sir.
in your favor. You know, they have by a particular letter they have apprised the authority. Then why have you not included East Coast Railway as
Yes,
a
ma'am.
party?
Opposite party side, ma'am. Deputy Chief Manager, Construction, Talche Bimodgar Project, Sundargarh, East Coast Railway, ma'am. He is opposite party of 5. To whom, my lord, they have forwarded the letter, ma'am.
So what response you have got?
Absolutely no, madam. Since the date that has been forwarded, no communication, neither they have intimated me to appear before the authority concerned, nor no communication at all.
So who is to obtain instruction in this matter? East Coast Railway by ki appeal to you?
DSJ.
Hmm?
DSJ will be appealed.
What is it?
Union of India is
Achanti,
and
Deputy
judicial failure. The now in the panel of the
senior panel counsel.
In course of the
They have not served.
give a copy to me so that you will obtain instruction on
yes,
this
ma'am.
matter.
In course of the
The petitioners Pradhanam Vishwa and Janaki Vallabh Vishwa have filed this writ petition for quashing the notice of eviction issued by opposite party number 4, land acquisition officer, Talcher, Bimola, God, NBG, Rail Link Project Sundargarh. Dated 15/11/2024 under Annexure 11. With the further direction, the opposite party number 5, the deputy chief engineer, bracket reconstruction to Talcher, Bimalgarh, NBG, Railway Link Project Sundargarh, East West Railways Onboard Division, take necessary decision consequent upon the issuance of the letter dated letter number for the 305 dated 7/8/2024 by the opposite party number 4. When counsel for the petitioner to the attention of this court to Annexure 10, which is the extract of the order dated 7/8/2024, passed by opposite party number, wherein while adjudicating deciding the representation of the petitioner as per the order of this court dated 25/4/2024 passed in WPC number 42220 of 2023, it has been concluded that the East Coast Railway is the apt authority to take a decision in favor of the petitioners, and accordingly, by letter number 305 dated 7/8/2024, the opposite party number 5 has been apprised of the case and subsequently requested to take necessary steps and decisions in favor of the petitioner at an earliest. It is the contention of the Land Council for the petitioners that even though such such letter was issued on 7/8/2024 to the opposite party number 5, but no action has been taken by the said opposite party. Rather, the petitioner has been served with notice of eviction on 15/11 dated 15/11/2024 by Annexure 11. Since the Deputy Solicitor General, Mr. Pari, is to appear for the East Coast Railways, bracket like the opposite party number 5, let a copy of the writ petition be served on the Land Council, so and so, during course of the day. And let Mr. Pari obtain specific instructions as to whether any decision has been taken by the opposite party number 5, in pursuance of the letter number 305 dated 7/8/2024 issued by the opposite party number 4. Matter be listed in the week commencing from 10th February 2025. Yes. Okay.
Item 11.
Where page is it? The equipment or the villagers of village Gopalpur
As before your lordship, challenging annexure 6.
Your representation is filed annexure 7, and that is pending before whom?
Pending before matter opposite party number 4. But
Opposite party number 4. That is dated 11/11/2024.
Matter.
You have got no response.
No response. But problem is that matter by virtue of the annexure 6, the revised guidelines, now they are going to have the fictional from their.
Let them consider the representation. So annexure 7 is to be considered from the date of production of the certified within 3 months. Yes, next.
Matter, I pray, don't pray matter, till such a decision is taken, no decoration.
Take steps immediately during by tomorrow you produce the certified copy. Yes, next.
Till then matter.
Sorry.
Item 12.
Edit for those and set a year.
Yes,
Critical
item
area
number.
by
Appearance for opposite party number 1 and
Yes,
Union of India.
Union of India like ये case study last case study. Yes,
Senior panel.
कहाँ ना लिखी हुई दे दो ना जब solicitor general को से तो जहाँ ना लिखी हुई तो दिया ही थे Yes, item number 12.
I don't mean sorry. Till such a decision is
Sorry,
taken,
we do not know the position and we have not heard also the opposite party. We cannot pass such order. Yes, next.
May I please, madam. Even though the behind of the question standard was acquired for the purpose of constituting the DO area which was voted by the opposite party, and the prisoner was treated as a separate family for the prisoner resettlement and rehabilitation policy management seats. But he has not been paid with the compensation by treating.
Where is your representation to get the compensation amount?
The copy of the representation was not with the prisoner now, but I humbly submit that
No,
Honorable Court may kindly
unless you bring it to the notice of the authority that you are entitled to get compensation and the reasons must be there and the documents must also be there with the representation, then he can consider.
it was filed
The authority who has to consider your compensation amount is the opposite party number 4. So you must bring it to the notice that how you say that you are entitled to get the compensation.
but unfortunately the copy of the representation is not.
Then you file a fresh one.
I'll file.
Listen, this writ petition has been filed by the petitioner CORAM Shaw for a direction to the opposite party number 4 to extend the benefit as due and admissible under Grants of Policy 2006 in favor of the petitioner by treating him as a fully displaced person, public family. When we put a pertinent question to the Land Council for the petitioner as to whether he has submitted any representation before the opposite party number 4, substantiating the claim. The answer was in affirmative, but the Land Council submits that the copy of the representation is not available with the petitioner, for which it could not be filed with the writ petition. Let him file a fresh one. Well, the Land Council for the state submits that if a fresh representation is filed before the opposite party number 4, highlighting his grievances, the same can be considered by the opposite party number 4 within a specified time limit. Hearing the Land Council for the respective parties without expressing any opinion and the merits of the case, it is observed that in the event the petitioner filed for the presentation before highlighting his grievances, along with the copy of this order, the same shall be disposed of, then time limit taken and order to be communicated. Yes.
Item 13.
Item 13, my lord. Item annexure 6 is my representation pending before OP3 collector.
Annexure 6 is the representation.
Yes, ma'am.
Pending before
OP3 collector.
annexure 6 OP3.
Item 14.
And the next week, maybe. Hello, one I in course of the day or day after coming. Let it.
आई करेगा ना कर लेंगे.
मैं आज ही जाइए कहते आज ही हम कल
अच्छा. Submission is Mr. M.K. Patil and Central Government Council. Senior panel counsel submits that the matter may be taken up the week after as some interim applications are likely to be filed in this writ petition. This matter will be commencing from 10th February 2025 along with IA, if any, filed in the meantime. Yes.
Item 15.
Mr.
May I
Yes.
discuss the land and house of the petitioner acquired by the opposite from the NHI matter. In the identical matter, the son of the petitioner, your city is to notice on 24th January. That has not been uploaded. 1819.
What's the number?
1819.
Number 30 uploading the
କେବେ ଥିଲା
24th January. Yeah, ସେ ମୁଁ check କରିଥିଲି ସେ
WPC 2429.
January ଥିଲା.
नहीं order number case number
1819.
1819 of 2025.
25.
It is actually uploading. Please wait, let us verify. One 819
Thanks.
2025.
Not sure, could be.
अपलोड कर दिया ये सेम मैटर
Same.
ये ऑर्डर कर दे जहाँ है ना इशू नोटिस रीच काउंट करते हैं now the matter to be listed along with that
The next date ଅଛି 3rd March.
1819 of 25
3rd March କରିଦେବେ ସେଇଟା 3rd March.
और मात्र
ଯାହା ଲାଗୁଛି
हाँ
ହଁ
लिखा है पोस्टिंग डेट लिखा है yes next
Item 16.
Item 16 is a common matter on the
yeah this was a match
Item 17.
opposite party number similar type of matter already before that is the 64 proceeding is there.
correction करिए दीजिए
And the 64 is can you apply the 64 of the action?
he wants this representation is to be disposed of similar orders have been passed yes next these are the two matters
18 also same.
17 and 18 disposed of yes
Item 19.
Third, item 19 and 20 are also covered matters.
see sold over there they don't display
19 and 20.
correction कर दीजिए ना
Item 21.
21, I put opposite parties. Yesterday also this matter was reached, but the other side was not there.
नहीं सी जो मिस्टर फंडास लेडी के
Mr. Panda was appearing. Last 3-4 days or he was appearing. The order sheet also mentioned. Yesterday also.
yesterday this matter was there.
No,
Wait अच्छी मेरा पूरी मैटर पहले से जो नालपुर
2021 they have filed, but this 1 year also they have taken several legends.
ये rehabilitation scheme
Compassionate appointment. That has been rejected by tribunal.
That was rejected against that, yes.
Amendment would have filed.
They had filed an amendment. So that I had filed a reply, but that had not come on record.
Have you solved a copy?
Yes, yes. Absolutely.
IN number 797 of 2025. There is an application for amendment. The Land Council appearing for respondents number 1 to 3 filed the reply affidavit to such interim application in which
Already filed.
already filed so and so, and it is stated that the copy of the same has already been served the Land Council for the petitioner. None appears for the petitioner. Is this matter out of date? Yes.
Item 22.
Next matter.
Item 23.
So loan visa application is not a solved matter. Number 375
Copy has not been served. You are Mr. Ajay Kumar Das. The council is not here. And 373 of 2020 you have.
373 delay petition, not order.
No, here also this condonation application and WA that has also not been served on you.
Only delay petition solved.
Delay petitioner. So how much delay is there?
83 days.
Have you filed any objection?
No filing.
You don't want to file.
Okay, COVID-19 period.
It's all right. We just want to know. Okay, none appears for the appellant. The Land Council appearing for the respondent number 1. The 375 submits that the copy of the writ appeal has not been served on him. Stop. Let the Land Council for the appellant serve the copy of the writ appeal on the Land Council for the opposite party number 1 within a week. Matter be listed. Okay, along with WA number 373 of 2020. Copy sir, non appears to within a week tam copy debe, it will come so and so, and then we will consider the delay condonation application in the connected matter. Yes.
Item 24.
May I please? Item 24, the order of non-tribunal is under challenge. A detailed lecture is required for proper adjudication from my clearance. May I please? Candidate.
Senior panel counsel.
Mr. Bhavani Shankar Raiguru, Learned Senior Panel Counsel, Government of India, has filed the appearance memo, which is taken on record. The Learned Counsel for the petitioner submits that for final adjudication of this writ petition, a detailed date chart is required to be prepared, and some time may be granted in that.
Readings have been completed.
Huh?
Readings have been completed.
The date chart are there.
As interim order is continuing in my paper, I am not pressing for any long argument.
ଆପଣ କୁହନ୍ତୁ କେବେ ଦି ଜଣ ଯାକ କୁହନ୍ତୁ ଆମେ ରଖିଦେବୁ next week କି ତାପର week ଯେବେ କହିବେ ରଖି
Second, when it had commencing six.
second week commences on 10th, so let it be on 11th.
Fine.
All right. On consensus of both the parties, let this matter on 11th February 2025.
Interim order to continue. Okay.
Interim order is there.
Fine.
Interim order ତାକୁ ଅଛି କହୁଛନ୍ତି continue କରିବ till next week.
Sir, item 21, which is a passover expected. Can it be taken off, sir?
Obligement.
Because the opposite party has.
Yes, they have filed their reply.
I received. Come to the.
So now it is to be taken.
For allowing the amendment, that is formal in nature. Order
Yeah,
6 rule 17.
we have already fixed a date and say non-appears to category. On that date will come. A week after it will come. Yes, next.
Item 25.
The last order.
20. Which order you want to place?
No, 9th December 2024.
Well, please place it in that order. That he, whatever, let's see.
Person no.
9/12/2024 bhalla. Yes, please place from that work form. Yeah.
The writ petition has been filed by the petitioner Supasri Patnaik for setting aside the postpone of the input order that is 26/6/21 passed by the Central Administrative Tribunal Cuttack Bench in OA number 12 of 2018, wherein after quashing the order of the dismissing authority dated 21/8/2017 in the order of the appellate authority dated 12/12/2017, it is held that the petition is entitled to be reinstated in service along with all the service benefits. So far, the back purchase is concerned, it was limited to 50% upper entitlement. It was further directed by the London Tribunal that the entire exercise shall be completed within a period of 2 months from the date of receipt of the copy of the order. London Council for the petitioner submits that in pursuance of such order, the petition has already been registered in service and she is now posted at Assam as junior clerk, and 50% back purchase has already been disbursed to the petitioner. However, the London Council has relied upon the ratio laid down in the case of some 3 judgments matter as stated that the petition is entitled to full packages. The London Council for the opposite party has already filed counsel approval. copy of which is stated to have been served on the learned counsel for the petitioner. And after taking the reference from the learned counsel for the petitioner, he takes some time to find out the latest decision on the point of title.
Yes.
I have given 3 judgments, and another judgment also. My lord, the learned Mr. P.K. Pahi is. I'm assisting him, and I'm submitting my appearance today for the first time because I've been appointed CGC recently.
Yes. File your appearance memo.
My lord.
Yeah. What do you say about this? Have you gone through this order?
My lord, I have gone through the order.
Yes.
I have recently seen the file because it
Yes.
was with the previous council. Meanwhile, our whole panel.
So what do you want?
What do you want?
My lord, since it's already been heard, only the question of the decisions is there.
Yes.
And there are successive decisions on no pay, no work, and there are also
No,
decisions.
no. So are you going to address us or you want an adjournment?
I would require a short adjournment.
Say that.
Say that.
Well.
He has already placed 3 decisions
My lord.
of the Honorable Supreme Court, and on that day, you took time that you find out some latest decision on the point of back wages. Right?
My lord.
That is how the matter was adjourned to today.
My lord.
Now you have to either give the decision or whatever you want to say. देखो, आज जो डिसीजन दोचन दियो मेंशन कर दो ऐसे 3टा डिसीजन छाड़ी कि अच्छा और एते कोन देखिन दीटा कॉपी ना को ओ दीटा डिसीजन ना 3टा कॉपी दे दी दीटा है ना मत चलो
So, Mr. Your submission is the last occasion. Everything has been heard. I was not there. I have not heard.
Even I.
Nor were you there. So.
Apologies, my lord. My name does not have Mishra.
Sorry. Then
Bharadwaj.
Mr.
Pushparaj
Bharadwaj.
yes, sorry.
What is the full name?
Pushparaj Bharadwaj.
Pushparaj Bharadwaj. Land Council files the appearance memo. So also the appearance memo of Mr. P.K. Paringor Nata Ageleke. The appearance memos are taken on record. Here is the order dated 9/12/2024. In addition to the citations which were placed by the Land Council for the petitioner on that day, which have been reflected in paragraph number 2. Today, the Land Council for the petitioner has cited another decision of this court in the case of Govinda Malia versus UCO Bank, reported in 2015 Supplementary 1 OLR 203, which is taken on record. Mr. Bhardwaj, Land Council, submits that what time is it?
If it is not an inconvenience to my 2 weeks.
No, tell us a date, so it will come in the supplementary list, whether it will be on 11th, 12th, 13th, whatever date you say. 12th. Place this matter on the consensus, place this matter on 12th of February 2025 as straight for by this one. So to find out, to cite some decisions, please for cite some decisions. Latest decision on the point of back wages. Mr. Bhagwas shall be reflected in the cause list transcript. Yes, just coming with
Item 26.
I beg your pardon. In this matter, moment, I am appealing for Union of India. This is item number 1. And today I am filing my reference note. 26.
Item 26.
26.
Are you sure your name appears on the petitioner? Just check the list.
Mr. Rasul,
All list ଟା ଦେଖିଲେ? Item 26 ତ?
Fine.
ଆପଣ ନାଁଟା କଣ?
Srinivas Satya.
ଦେଖିଲେ?
ଭୁଲ
ଭୁଲ ଅଛି?
ନା ଏଠି ଠିକ ଅଛି ଆପଣଙ୍କ ବୋର୍ଡରେ ଠିକ ଅଛି ସେ ବୋଧେ ପ୍ରିଣ୍ଟିଂ ରେ କଣ ଭୁଲ ହେଇଯାଇଛି ବୋର୍ଡରେ ଠିକ ଅଛି
ବୋର୍ଡରେ
ଆଜ୍ଞା
ଏମିତି କେମିତି ଭୁଲ ହେଲା?
ସେ ଡ୍ରାଫ୍ଟ ଲିଷ୍ଟରେ ଭୁଲଭାଲ ହଉଛି ତାପରେ କରେକ୍ସନ କରିକି ପଡୁଛନ୍ତି
ଆଚ୍ଛା ସେମିତି ବି ଭୁଲ ହଉଛି ନାଁଟା ଭୁଲ ଲୋକ ପାଇଁ ଲେଖି ଦଉଛନ୍ତି ନାଇଁ ନାଇଁ ଡ୍ରାଫ୍ଟ ଲିଷ୍ଟରେ ଭୁଲ ହେଇନି କଲ୍ ଲିଷ୍ଟରେ ଠିକ ଅଛି ଦେଖନ୍ତୁ ବ୍ରିଫ ର ଫର୍ଷ୍ଟ ପେଜ ରେ ଦେଖନ୍ତୁ ଡ୍ରାଫ୍ଟ ଲିଷ୍ଟରେ କିଛି ଭୁଲ ହେଇନି
ହଁ ଏଇଟା ବି ଲିଷ୍ଟଟା ଭୁଲ ଅଛି
ନାଇଁ ଲିଷ୍ଟଟା ଭୁଲ ହେଇନି ଲିଷ୍ଟ ଇଜ ଆଜ पर द ବ୍ରିଫ ବ୍ରିଫ
ହଁ
ଏମିତି ଭୁଲ
ଲିଷ୍ଟଟା
ଥିବ
ଆଜ पर द ବ୍ରିଫ ଅଛି ବୋଧେ
ବ୍ରିଫ
କାହିଁକି
ଟା
ଆମ
ଭୁଲ
ପାଖରେ
ହେଇଥାଇପାରେ
ଯୋଉ ଏଥିରେ ଯୋଉ ୱେବସାଇଟ ରେ ଦିସ୍ ଲିଷ୍ଟ ଶୋଜ
ନାଇଁ ଆରେ ଆମେ ପରା ଫର୍ଷ୍ଟ ପେଜ ଟା ଦେଖୁଛୁ ଅଫ ଦ ବ୍ରିଫ ଆପଣ ବି
ଆମେ
ଦେଖନ୍ତୁ
ଦେଖି ସାରିଲେଣି
ଶ୍ରୀନିବାସ
ଏଇଟା
ଫର ଦ ପିଟିସନ
ଆଜ୍ଞା ଏଇଟା ଆଉ ଗୋଟେ କଣ ପୁରା
ଦେଖନ୍ତୁ ଆପଣ ଅପିୟର କରିକି ଭୁଲ ଆର ସାଇଡ କୁ ଅପିୟର କରୁନାହାନ୍ତି ତ ଦେଖନ୍ତୁ
ଆରେ ଏଇ ତ ମୂଳ ନାହିଁ ଆମ କେସ୍ ଏଥିରେ ଆଜ୍ଞା କିନ୍ତୁ
ଏଇଟା କ୍ଷୀରଦିନୀ ଦାସ ତ
ଆଜ୍ଞା
ଶ୍ରୀନିବାସ
Yudhini Dasre, Mr. Mishra. Again, you are appearing for opposite party. Opposite party.
then who is appearing for the petitioner?
My friend is appearing for it. You are Mr. Srinivas.
ठीक ଅଛି ଆଉ ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ କଣ କହିଲେ
Union of India,
ତାହେଲେ ଠିକ ଅଛି
by virtue of an amendment,
I thought he is saying Union of India, so I thought na petitioner pe achi. Then there is no problem.
it is criminal list. Union of India, there to party nahi kon hala. Minor. In the first item, amendment allow number 21,361 of 21, which is the order in which it was allowed. Amendment. Order dated 16/4/2024. Okay. Passed in IA number 14,171 of 2020. Which I have filed. Then you filed the consolidated petition. I have filed. Where is that consolidated petition? ସେଇଟାକୁ ଆଣିଲେନି ଉପରକୁ ଏଟା ପୁରୁଣାଟା ଆପଣ ଦେଖିଲା ବେଳକୁ ତା ଦେହରେ ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ନାହିଁ ଯୋଉଟା କନସୋଲିଡେଟେଡ କଷ୍ଟ ଆଇଟେମଟା ଯୋଉଟା ଫାଇଲ ହେଇଛି ସେଇଟାକୁ ପଛକୁ ରଖିଦେଲେ କେମିତି ହବ ସେ ଆଜ୍ଞା ସେଥିରେ କଣ ହେଇଛି some different paragraphs have also been added ଆଉ ଏଠି ଅପୋଜିଟ ପାର୍ଟି ଗୁଡା ଚେଞ୍ଜ ହେଇଯାଇଛନ୍ତି ମାନେ ମୁଁ ଆପିୟର କରିଥିଲି 1 2 3 5 କିନ୍ତୁ ସେ ଶିଡ୍ୟୁଲ ଅଫ ଆମେଣ୍ଡମେଣ୍ଟ ରେ ସେ କରିଦେଇଛନ୍ତି ମତେ 2 3 etc so ମୁଁ କାଉଣ୍ଟର ଯୋଉ ଫାଇଲ କରିଛି that will also be confusing. Union of India was added. He should have been added as last opposite party. First opposite party.
Consolidated cost item ସେଟା ଆଉ କଣ ଅଛି ପୁରୁଣାଟା ଅଛି ଲେଖା ହେଇନି consolidated cost item.
What is your amendment rate for in that 14171? In that application, I have made clear to add Union of India, represented to Ministry of Health, as opposite party number 1 and the best opposite party and the present of and the opposite party number 1 to 6 be renumbered as opposite party number 2 to 7. Now you see your consolidated writ petition, cost item. Consolidated cost item le kahi Union of India kahi
ଜିନିଷଟା ଦିଆହେଇଛି ଏଟା ଜିନିଷଟା ସେ କଣ something wrong. That is 2021.
consolidated ଲେଖା ହେଇଛି consolidated same thing sir. Council ଯେତେବେଳେ consolidated cost title ଟା ଫାଇଲ କଲେ ଫେର ତ ଆगे କଥା ଲେଖିବା କଥା consolidated cost title ସେଇଟା ବି ନାହିଁ ଦ୍ୱିତୀୟ କଥା ଆପଣ ଯାହାକୁ ପକ୍ଷ କରିବେ ନୂଆ ପକ୍ଷ ସେମାନଙ୍କର ନମ୍ବରଟା ତା ପରକୁ ଆସିବା କଥା ଆଉ ଆପଣ एक तो ठीक अच्छी ताकू भी करना दी एवं से पक्ष मध्य टोटल आड ହେଇନି consolidated cost title ରେ ଯାହା ଆମ ପାଖରେ ଅଛି ତେଣୁ ଆପଣଙ୍କ ପାଖରେ consolidated cost title କିଛି ଅଛି କି କାଇଁ ଦେଖିଲେ
ଆପଣଙ୍କ ପାଖେ ଅଛି ଆମର ଲେଖା ହେଲା filed but it is not available
ଦେଖି
office note କହୁଛି file ହେଲା ଦିଟା ଗଲା କୋଉଠି
এটা কনসোলিডেটেড
ଦେଖି consolidated ଏଟା ସି ଏଟା ହଉଛି consolidated cost title main of India ରେ ଅଛି ଏଇଟା ଏଇ cost title ଟା ନାହିଁ
hostel ଟା ଗଲା କୁଆଡେ noting says ଅଛି but office note says filed but ଗଲା କୁଆଡେ missing
ସେ consolidated writ petition file କରିଛନ୍ତି because along with
ହଉ
ଆଜ୍ଞା
ସେଇଟା ବି
ନାହିଁ
ନାହିଁ
ସେଇଟା ନାହିଁ ପରା ସେଇଟା ହଉଛି ନାହିଁ
ଭୁଲରେ ଫାଇଲ କରିଦେଇଛନ୍ତି କି ପୁରୁଣା ଜେରକ୍ସ କରିକି
No, no, I have found that one.
no that is not filed and council the
ଆଉଥରେ file କରିଦେବେ
we filed it because the same thing you have filed ये जो consolidated writ petition टा नहीं तारो
ଆଉଥରେ file କରିଦେବେ
देखो the and you have been served with a copy of the
yes
अच्छा
I have been served with a copy but without annexure.
Ah,
No petition has been served.
हाँ
No annexure.
we'll do it ଆପଣଙ୍କର ଯୋଉ consolidated cost title ଟା ଦିଆ ହେଇଛି ତା ଦେହରେ Union of India ଅଛି opposite party number 1 all right ଦେଖନ୍ତୁ the learning council for the petitioner submits that he will file the consolidated writ petition during course of this week এই সপ্তাহ ভিতরে ফাইল করিবে during course of this week and stop the learning council for the ଆପଣ କାହା ପାଇଁ appeal କରୁଛନ୍ତି
For Union of India, my lord, Ministry of Coal,
ଦିଅନ୍ତୁ ଆପଣଙ୍କର
along with
appearance
DSJ and
ହଁ ଠିକ ଅଛି
Planet View.
Sure. Prashanna Kumar Padi, and Deputy Solicitor General of India, along with Pranav Kumar Prashaya, enters appearance for opposite party number 1, Union of India, and the appearance memo is taken on record. The Learning Council for the Union of India submits that though he has received the copy of the consolidated petition, but annexures are missing. The Land Council for the petitioner submits that he will supply all the annexures to the Land Council for the Union of India by tomorrow. ତାଙ୍କୁ copy ଦେଇଦେବେ କେବେ ଆଣିବ ଆପଣଙ୍କ matter reading complete counter
ନାଇଁ counter ମୁଁ file କରିଛି they may also file a counter
ସେ file କରିବେ rejoinder ବି file ହେଇଯାଇଛି ତ so reading complete ହେଇଛି ତ ଆପଣଙ୍କୁ date କୁହନ୍ତୁ କେବେ ଆପଣ
2 weeks after ଆସୁ
date କୁହନ୍ତୁ ଆପଣ ଯାକ ଅଛନ୍ତି ଗୋଟେ date କୁହନ୍ତୁ ଦେବେ
20th
20th leave this matter on 20th of February 2025 as agreed upon by everybody along with ଏ ଯୋଉ ଦିଟା ଯାକ ଆସିବ
Second items, all those similar application filed, but inadvertently order has passed. Similar, I
wait. अच्छा कुहନ୍ତୁ
into the
WPC number 21901 ତାଦେହରେ IN number ଟା କେତେ
14170
14170
to was filed to amend the
अच्छा से तादेहरे जहाँ ये जो आईए रे जहाँ ऑर्डर ହେଇଛି जो प्रथम टारे है ना अमेंडमेंट ପାଇଁ से ऑर्डर आने के कॉपी कर पेस्ट कर दे और जानी भी से दा अपडेट कर दे
But in this is appearing for CGC.
yes madam as a consolidated petition to be filed copy to be served on the land council for the other copy ଦେଇଛନ୍ତି ଦେଇନଥିବେ ତ allowing consolidated writ petition be filed served on the land council for the opposite parties the Deputy Solicitor General along with ଇଏଟା allow ହେଲା ପରେ ଏଟା ଲେଖିବେ କାରଣ ଏମାନେ ଆଡ୍ କଲେ ତାପରେ ଏମାନେ ଫାଇଲ୍ କରୁଛନ୍ତି ହେଲା ଶ୍ରୀମତୀ ପ୍ରତିମା ନାୟକ ହେଲା enters appearance first one the appearance memo taken on record the name of the Land and Deputy Solicitor General, so also Mr. Sima Naik shall be reflected in the corporate transport. That was the item, second item, how I to dispose of for the Yuta 14170 ଅଛି amendment, ହେଲା সেটা dispose of হবে, সেটা হচ্ছে amendment price 14170 of 2020 amendment dispose of. Consolidated repetition Mr. Mishra को देवे plus Union of India रो Adam को दे दे. Yes, next.
Item 27.
That's there. Can you see your lordship's last document?
There is a case now.
कौन पूछेगी?
Directed to find out all similar cases filed by the state government. My learned senior had submitted that there are 19 cases, but somehow we have not find. Just 4 cases, which is in your lordship's board, that is there. Other cases, we could not find.
And if I is saying that it is not 19, it is 4.
Just let us see. There are 13111 14454 is 2. How did I put up?
8138 of 2022 disposed of and dismissed.
नहीं pending आउ आज छड़ा कुछ pending अछि कि
आज छड़ा
Verify condition to file. That is what your lordship's direction to find out if that is
it's
there.
all right. So no, in the cause list we have 2 cases in item number 27. So one is 3112 of 2022, another is 14454 of 2022. That's all.
That's all.
Yes, on account.
In fact, lordship, it is.
That is, there is a case that the state filed a writ petition challenging the order passed in a show motor religion in 2003.
Just a minute. If the state is the petitioner, why are you arguing the matter?
Because matter is covered, already decided by this.
Oh,
So similar matter dismissed by.
Kain.
That is 8138 of 2022. I had supplied the order last.
The matter was start this matter, but last.
ठीक है,
So delete this.
8138 रे जो order टा
आगे,
सही order टा ऐसी pass हो गया.
Same order.
अच्छा. Related stage रे जो तू
Related state, one is 19 years, one is 24 years.
এটা আছে. তো টা
Computer को बाहर produce नहीं सही. order टा pass. এটা ওটা
দিলে রে যাই. এটা কেবেকার অর্ডারটা মানে
12/3/2024.
नहीं এই जो इम्पुन ऑर्डर आज रे 2003
Same order.
रिट पिटिशन फाइल केसी केते 20
This has not been challenged by the state
No,
in the
no.
Supreme Court.
No.
You've taken instruction
Supreme Court.
because we'll record that.
Their lordship are referred to that.
No, इतना नहीं. ये order.
Challenge करना है.
So we'll record your submission if you dispose of.
Neither ignore nor.
better same here for the and like it away a similar matter has already been disposed of in WPC number 8138 of 2022 by the order dated 12/3/2024 and taking into account that the informed order was passed in year 2003 and the writ petition was filed in 2022 and there was delay of 19 years in filing the writ petition. The writ petition was dismissed. And this court has taken to account the judgment.
Delay যদি 19 years হয়েছে সেটা
Same order according to the petition merits no consideration and the same with the
Manoj, the
dismissal.
only difference, if I can just submit it, so lordship stand by. Only difference in the two cases, that was in the press admission stage, and this is in this case before your lordship, the counter as in that is
No,
the only.
but it was filed in 2020.
Yes, yes.
That the first case that 24 years after.
Hold on.
The
First
98.
case.
Past case. So 3112 of 2020. That is the order of the 98 version.
আচ্ছা প্রথমটা হচ্ছে পরেরটা হচ্ছে 1998 ହେଲା ସେକେଣ୍ଡଟା ହଉଛି 2003 ହେଲା ବାକି ସବୁ ଇଏ କରି replacement ସବୁ ଦିଟା ଆଜି ଏଥିରୁ ଗୋଟେ ଲେଖି ଦିଅନ୍ତୁ ଯୋଉ Land Council for the State submits that the aforesaid order dated 12/3/2024 passed in WPC number 8138 of 2020 has not been challenged by the state before the Honorable Supreme.
Item 28.
813 না? সেটা রিলাই করতে হবে সেটা নাম্বারটা গেছে 8138 হ্যাঁ হ্যাঁ ঠিক আছে এই রেকর্ডটা ওটারে কি ওকে না ছিল
আচ্ছা হার্ড লিখিদেবে
স্যার মিস্টার রয়
এটা তো স্টেট কাউন্সিল কর না লিখিদেবে ମିଷ୍ଟର ବେହେରା ପ୍ରଭୁ କୃଷ୍ଣ ବେହେରା ଆଉ ବାକି ଏଠାରେ ଲେଖିବେ ନିରୁଦ କୁମାର ସାହୁ ହଉଛନ୍ତି ଅପୋଜିଟ ପାର୍ଟି ସେକେଣ୍ଡଟାରେ ବି ପିପି ବେହେରା ଲେଖିବେ ଆଧିରେ ଇଏ କାହା ପାଇଁ କାନ୍ଦଳି ରହିଛି ସେକେଣ୍ଡଟା ଯୋଉ WPC 144 of 2012 ସୁକାନ୍ଦଳି appear କରୁଛନ୍ତି ହେଲା ତ not able hard to answer. Yes, ma'am.
Item 28.
You are for the petitioner.
I'm appealing for the petition.
I'm counsel for the petitioner 6 for an adjournment. Yes, next.
Item 29.
Because I am applying to appeal and minor, so it's time to file my written notice of them. And the date set. Matter is ready for argument.
I have for the respondent private party and respondent or file.
You are for the
Appellant.
appellant. So the last order was passed on 18/12/2024. And it appears the counter affidavit has been filed by the respondent number 3 and 4. Sub-Collector Jagatsinghpur and CDPO Raghunathpur. Land counsel for the appellant and land counsel for the respondent number 5 submitted that they have not yet received the counter affidavit filed by R3 and R4. Now they have you have
Received copies.
Well, I have not. I have received the copy.
you have not received.
Respondent number 5.
Please
also recall
please survey the land counsel for the appellant submits that as per the order dated 18/12/2024 he has received the counter affidavit filed by the respondent number 3 and 4 sub-collector Jagatsinghpur and CDPO Raghunathpur respectively. However, the land counsel for the respondent number 5 submits that he is yet to receive the counter affidavit filed by respondent number 3 and 4. The land counsel for the state submits that during course of this today, during course of the day, he will supply the counter affidavit to the land counsel for the respondent number 5. Since Mr. Satyaprakash was on to what do you want to what further?
I want to file my written notice of assumption and date set.
All right, the land counsel for the appellant submits that for final adjudication of this matter, he intends to file the date chart as well as written note of submission. Let the matter be listed in the commencing from 10th of February 2025. The copy of the written note of submission be handed over to the land counsel for the state as well as land counsel for the respondent number 5 in the meantime. Yes.
Item 30.
Active Millard, I have filed an additional affidavit. I will solve the copy in the meantime, Millard. You may call this matter.
Additional affidavit is on record.
No, Millard. I have filed.
When you have filed?
Yesterday.
You are appearing for
Petitioner.
Mr. Ranjan Kumar Nayak, Land Council, appearing for the petitioner, submits that yesterday he has filed an additional affidavit and copy has.
I will solve it.
Stop. Let the said affidavit be placed on record. The Land and Council for the state as well as the Land and Council for the opposite party number 6 to 11 submits that they have not yet received the copy of the additional affidavit. Let the copy of the additional affidavit be served on the Land Council for the state as well as on the Land Council for the opposite parties number 6 to 11 by tomorrow. By tomorrow. Matter will be listed in the week commencing from 10th of February 2025.
Item 31.
As per the lawsuit / order dated 17/12.
17/12.
My lord. Counter affidavit is not preferred since everything is in the record. Order of the tribunal. You are for the? I am for the opposite party. You don't intend to file any. Okay, what do you say? My lord, I am filing the death cert and written note. My lord, is the lawsuit. Have you handed over a copy? The Land Council for the opposite party has filed date chart. So also written note of submission in court today, giving the same to the Land Council for the Union of India. Yeah, what is it? My lord, in this case, my lord, I filed my written note of arguments. The Land Council for the Union of India submits that he may be given some time to file the written note of argument. Matter listed in the convention from 17th February 2025. Written note of submission be filed by the Union of India in the meantime, serving a copy on the Land Council for the opposite party. Yes.
Item 32.
32, my lord, I say when you take granted to file rejoinder, and in spite of a lawsuit order, OP number 2 has not filed counter. 3 and 4 has filed counter. I will file a rejoinder within a week. You are for the petition? I am for the petition. My lord, Parawise comment already received, my lord. You are for the number of OP number 2, order dated 24 July 2025. The Land and Council for the petitioner submits that he has received the counter affidavit filed by opposite party 3 and 4. Opposite party number 3 and 4, and he intends to file the rejoinder affidavit. Stop. Land Council for the state submits that he has received the Parawise comment and will file the counter affidavit within the 1 week after. Within a week. Matter be placed. Mr. Keberokio. Sir, I am appearing for OP number 3. OP number 3. This is sir copies. Copy for कही दूची जे केबे रखिबा कोन आपण जेबे कहिबे रहइबो 1 week or 2 weeks after. अच्छा 17 week रे रखि दूची supplementary list आसे हमें matter is listed on 18th February 2025. Counter affidavit copy is also the rejoinder affidavit if filed, copy be handed over to the respective parties. Yes.
Item 33.
Order dated 1/10/2024. I have been directed to the Union of India to take instruction.
Order dated
1/10/2024. Whether it is compliant or directed specifically in the last part of the letter concept of the petition submitted that the petition it has been mentioned that the citizen have not accepted the form and it came to know from reliance that promotional post have not been given within a period of retirement 8/2/2020. In paragraph 8 of the writ petition, it has been stated that petitioner appeared in person before the tribunal and apprised it about the circumstances under which he was not able to receive form number 6. Mr. P.K. Badi, learning DCA, appearing for the Union of India, seeks for an adjournment to obtain instruction in the matter. Thereafter, my lord,
This is my lord. I have already prepared my counter and set it for vetting. And my lord, one more thing, my lord. As per the instruction, my lord, the department has asked for all the relevant documents for complying the order of the learned tribunal. But the petitioner has not availed the same, and
no, my lord, this is not correct, my lord.
No, there must be some documentary proof with them.
Huh.
When they have sought for some documents and that has been served on you, they must have got the copies with you. It's not that without taking any instruction, how do you say? They stated that some documents have been sought for from the petitioner.
My lord.
You take instruction on that. What is there?
That is no objection, my lord. I will give the document. Perhaps, my lord, that the order of the.
Have you got that copy of that letter in which you sought for the documents
No,
from
my
the
lord,
petition? Then
sorry, my lord, but
produce that also. Huh?
and I will file my detailed
Not
counter.
that will be done, but if you want some documents for consideration of his, so he wants that he is ready and willing to furnish the document, provided that why didn't you hand over to the land council for the
No, I will-
petitioner,
I will do
so that it will be forwarded to
Yes,
the
sir, I am
petitioner?
putting it
Yes, yes, no.
personal lord's order. I will.
All right, the Land Council for the Union of India, Mr. Pari, along with Mr. Gucha, submits that the counter affidavit is to be prepared within a week, and it will be filed and will also be handed over to the Land Council for the petitioner. However, he submits that for consideration of the case of the petitioner, the authorities wanted some documents from the petitioner
on 18/6 to 2020.
on 18/12
18/6 to 2024 it was sent by post and it was
18/6/2024,
and it was sent
and it was sent by post,
and the petitioner has refused to accept that.
and the petitioner has refused to accept. The Land Council for the State Union of India submits that he will produce the letter which has been issued to the petitioner on the next date. Stop. At this stage, the Land Council for the petitioner submits that if a copy of the letter will be handed over to him, he will instruct the petitioner to file the documents before the opposite parties. Stop. Matter will be listed in the week commencing from 17th for them. In the meantime, the Land Council for the Union of India will hand over the copy of the letter dated so and so to the Land Council for the petitioner. On receipt of which the petitioner shall comply the same, and this court will be apprised about such compliance on the next date.
Item 34.
Mr. Rao. Yes. Yes.
And the petitioner, the disciplinary proceeding was initiated against the petitioner. Regarding some.
Who is appearing for you? Yes. Pass on. Have you filed any counter affidavit? Give him a copy. So we are granting you 1 week time, and Mr. Deputy Solicitor General along with Mr. Abhishek Mahanti, Land Central Government Council, has filed the appearance memo, which is taken on record. The Land Central Government Council submits that the otherwise comments are likely to be received for filing the counter affidavit during course of the day, and only time may be granted for filing the counter affidavit. This matter in the commencing from 17th February 2025. Counter affidavit we filed in the meantime, serving a copy on the land council for the petition. Right. Yeah. Therefore, now forgive me. What is your good name, land council?
Shakti Prasad, SP.
Mr. R. Mr. S.P. Ross, land council for the petition. Yes. Come on 17th February 2025. Yes.
Item 35.
He filed Mr. Rakesh Sharma.
My lords.
Yes. And opposite party, Mr. Bhagavan Mahanti. Yes. Please the matter.
It's rare in the writ application.
Yes.
A period is to quash the order dated 18/9/2024 as per Annexure 4 passed by the executing court and direct the civil judge and direct the petitioner to make the payments as has been directed by the civil judge. Lordship may see Annexure 1, page 15. That is the judgment passed by in the LA case by the learned civil judge. The operating portion, Lordship will find at page 33.
Just a minute. Read the first paragraph of that Annexure 1.
Annexure 1.
Judgment.
This LA case is filed under Section 18 of the Land Acquisition Act 1894 by the Special Land Acquisition Officer SCCL Works, Bajajnagar, Jharsuguda, as the claimant Kishorimani Mishra received the compensation amount awarded for the acquisition of her land and trees on protest for enhancement of compensation amount. Hence, this reference under Section 18 of the Land Acquisition Act 1894.
Okay. On what was ultimately held?
Ultimately, it was held that they will get per acre 80,000.
Just come to that part.
Page 33.
33. Yes, please place that
order. The land acquisition case E and the same is allowed partly on contest against OP number 1 and 2, but under the circumstances without any cost. The present petitioner claimant named Kishorimani Mishra is entitled to get compensation at the rate of 80,000 per acre for the acquired land, along with 12% additional compensation, 30% solatium, and interest at the rate of 9% per annum from the date of taking of possession of the land till the date of payment, if paid within 1 year hence, and thereafter interest at the rate of 15% per annum from the date of expiry of the said period of 1 year till its actual payment. Since the claimant petitioner has received the compensation awarded by OP number 1 in respect of the above land and trees over it, the same be deducted from the aforesaid amount. The claimant petitioner is not entitled to any enhanced compensation for the acquisition of 30 number of trees standing over the land which was acquired. Accordingly, the reference is answered. Now, my question is, your lordship reads the order, the fifth line, where it says interest at the rate of 9% per annum from the date of taking possession of the acquired land till the date of payment. Thereafter, if paid within 1 year hence, thereafter interest at the rate of 15%.
Yes. Lordship
may see the date of judgment.
Date of judgment
Date of judgment is 25/4/2020.
25 na 27?
27/4/2020. We then thereafter execution case was executed, and we by annexure 3 series, the lordship will get it at page 42. We wrote to the petitioner that, may I read that?
Yes.
To Kishorimani Mishra, so and so, subject payment of differential decretal compensation as per order dated 27/4/2023 passed in LA Miss case number 20 of 1991. This notice is being issued to you to inform you that the senior civil judge Jharsuguda, after hearing the parties in the case, has passed an order dated 27/4/2023 in LMS case number 20 of 1998.
Okay, you have calculated and asked him to
Come and take the payment at 9% interest
and
within the time period.
okay, then what? That is the order dated. That is the letter dated 20/12/2023.
20/12 is the first letter.
Hmm.
Then 21/2/24 is the second letter. 26/12/2023 is third letter. We have issued 3 letters to them. Please come, deposit your documents, and we'll pay you the amount.
And postal receipts are
Yes,
also
those are also attached. I have attached to postal receipt.
So then
Now, what the executing court-
just a minute. Opposite authority of operating party देखिए.
Right.
80,000 टଙ୍କା for export to this one, so along with 12% additional so interest of 9% annum from the date of taking possession of the acquirement till the date of payment if paid within 1 year. So it has not been paid, but he has been instructed to come and receive.
And we'll
payment.
make the payment.
All right. Then what happened?
Now, the executing court, what it did after we filed our calculation sheet, the executing court has calculated the interest for first year 9% and thereafter from 1991 at the rate of 15%. Lordship will get it at page 52.
Calculation में भूल कौन अच्छी?
Interest 9% from 90 to 91.
नहीं, calculation page number 51 ने किसी भूल भाल नहीं.
No, 52.
52 रे कौन भूल अच्छी?
Interest he has calculated. Interest 9% for the year from 1990 to 1991.
9%,
9% and 15% from 1991.
Good.
The second, you also got
अच्छा, interest हाँ.
Interest 9% for 1 year.
सेटा तो ठीक हो जी.
हाँ, तापोरटा 15%.
और सेटा हवा कथा कहते हैं.
Like 9% as per the court's order. Lordship will see.
ठीक है.
1990 was the date of possession. Taking possession.
No, date of possession is thereafter 15% date of expiry of the sale.
If a lordship sees page 51, the executive court itself has written that if paid within 1 year, it will be 9%. May I read that?
Yes, yes. Yes, so the 15% जगह 9% हवा कथा अपन because you have complied your part.
Yes.
You have already sent 3 letters.
Yes.
To the petitioner, to the opposite party.
Yes.
To come and give those documents like bank documents for depositing in the account of the opposite party, right? But he has not come, rather he filed a execution case and this calculation is happening. Hey, what is your submission?
Yes, my lord, your lordship may kindly see the 19/3/1990. 87 is the section 4 notification for acquiring the land. And 93/90
ବର୍ତ୍ତମାନ କଣ ଅଛି ମୁଁ ଆପଣଙ୍କର ଏଲେ କେସ୍ କୁ ଅପରେଟିଭ ପାର୍ଟ କୁ କୁହାଗଲା
ହଁ ସେଟା କୁହାଗଲା
ଯଦି ଆପଣଙ୍କର ଅର୍ଡର ଇଜ ଭେରି କ୍ଲିୟର ଯେ ଆପଣ ଯଦି ବର୍ଷକ ଭିତରେ ଦେବେ ତାହେଲେ 9% per annum ହବ ଇଣ୍ଟରେଷ୍ଟ ହେଲା if paid ଲେଖା ହେଇଛି clearly if paid within 1 year.
Yes, if paid from the date of taking of possession.
Judgment date.
If paid from the date of obviously it is from hence mane kon hence mane the date of judgment. Hence means hochi date of judgment.
That is the statutory interest. Your lordship may kindly see 18 reference hela.
Mr. Counsel, Mr. Mahanti, the order is very clear that 9% if that is to be out there body interest at the rate of 9% per annum from the date of taking possession of the acquired payment till the date of payment if paid within 1 year hence. ମାନେ ଆଜି ଠାରୁ ବର୍ଷକ ଭିତରେ ଯଦି ପଇସାଟି ଦେଲେ ତାହେଲେ 9% ଇଣ୍ଟରେଷ୍ଟ ରେ ସେ ଟଙ୍କା ଦିଆଯିବ ଯଦି ତାଙ୍କ ତରଫରୁ ଏଠାରେ କୌଣସି ବ୍ୟତିକ୍ରମ ହେଲା ତାହେଲେ ଇଣ୍ଟରେଷ୍ଟ ରେଟ୍ ହବ 15% per annum ହେଲା ତେଣୁ ସିଏ ସେଇ ବର୍ଷକ ଭିତରେ ଆପଣଙ୍କୁ 3ଟି ଚିଠି ଦେଲେ ଯେ ବାବୁ ଆସ ଆଉ ଏ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡାକ ଦିଅ ତାହେଲେ ଆମେ ଆପଣଙ୍କ ଆକାଉଣ୍ଟ ରେ ଡିପୋଜିଟ୍ କରିବୁ ଆପଣ କିଛି ରେସ୍ପନ୍ସ କଲେନି ତାପରେ ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ଫାଇଲ କଲେ ତେଣୁ ଏଇ ପରିସ୍ଥିତିରେ ଆପଣ 15% interest କେମିତି ପାଇବେ?
Yes,
What is the
I'm explaining that. Under 18, it was referred to the court for enhancement of the company. Your Lordship Mechanic section 18. Your Lordship Mechanic it is statutory interest payable under the Act.
Admittedly, this order has not been challenged.
No, not that.
So that has reached finally.
So my submission is
27/4/2023 ର order କୁ
that is not
challenge ହେଇନି ତେଣୁ ତା ଦେହରେ ଯାହା ଲେଖା ହେଇଛି ଆପଣ ସେଇ ଅନୁଯାୟୀ ପାଇବେ
Yes, I'm just pointing out. Your Lordship Mechanic.
ନା ଆଉ ଅନ୍ୟ ଆଡକୁ ନେଲେ statute ରେ ଏହା କହିଛି
No, ମୁଁ ତାପରେ ଯିବି setting just. Your Lordship Mechanic section 18. Therefore, statutory interest has been mentioned. Your Lordship Mechanic section 28.
ଅଛି ସବୁଦିନ କେସ୍ ଉଠୁଛି ଗୋଟେ ବହି କଲ
28.
land of it.
ଠିକ ଅଛି ମିଳିଗଲା
23 is the mode of determining the compensation of reference.
23.
23, Your Lordship may kindly see. Matter to be considered determining the compensation by the court.
Yes.
23. Under various head, the compensation has been determined. And thereafter, Your Lordship may kindly see section 28. If the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land to the date of payment of such excess into court. Thereafter, provided that the award of the court may also direct that where such excess or any part thereof is paid into the court after the date of expiry of period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of such excess or part thereof which has not been paid into the court before the date of such expiry. So admittedly, the enhanced compensation amount has not been paid within 1 year from the date of taking of possession. So 1 year is the calculated 9%.
So, Mr. Mahanti, you on the basis of this proviso, if you think that in the operative part of the judgment, the London senior civil judge has was not justified that using that word hence.
Hence, hence mean from the date of taking of possession.
Hence mane date of judgment na aji too. Hence mane aji.
Excess
Hence
the excess amount is decided in that date. It cannot be on the date of forward notification.
ତେଣୁ ଆପଣ ଏଇ
Forward
ଅର୍ଡରଟାକୁ
notification
ଚ୍ୟାଲେଞ୍ଜ
paid
କଲେ
the amount, but the excess amount which was 80,000 that decided in 2023. How can it go back to 1987?
using not to
So that is a statutory interest.
No,
they have also paid in all cases. They have paid 1 year.
Where we have challenged it and 1 year is passed, there we are paying 15%. Where it is within 1 year,
we have to just go by the judgment, and the execution proceedings should also be in terms of the judgment. If it is no application has been filed challenging, so the calculation mistake is there.
In the Lordship sees the execution order for a moment, page 51 if a Lordship sees. The executing court itself writes that. At page 51, may I read your Lordship?
Yeah.
On the top, at page 51. Along with solution at the rate of 30%, additional compensation at the rate of 12%, and interest at the rate of 9% per annum from the date of taking possession till the payment made, and failing to pay at the amount within 1 year from the date of said order. That is the order of the civil court.
Yes. So in spite of that, he has stated it to be 15%.
15%.
So if it is to be set aside, then he is entitled to get how much amount as per your calculation sheet?
Calculation sheet, what we had calculated up to 31/12/2023, that will be 39,83,370.35.
calculation, Mr. Mahanti, ए कैलकुलेशन शीट टा ठीक अछि तो यदि 9% धरा जाए
9% I have to verify that.
ମୁଁ ଚିଠିରେ ଲେଖିଛି my letter has
ଟିକେ
stated
କଣ?
that amount.
39%.
ପଇସାଟା ସେ ପାଇବେ ନା
ଆଜ୍ଞା ଆଜ୍ଞା
ହିସାବ ପତ୍ର କରି ନେବେ ନା ଆଉ ପୁଣି ସେଠୁ
Deposit करनाहांती.
ହଁ
But
ଏଇ ଯୋଉ
till date they have not
ବର୍ତ୍ତମାନ
deposit.
15% କଥା ଭୁଲି ଯାଆନ୍ତୁ 9% ରେ ସେ ଯୋଉ ଏଇ କ୍ୟାଲକୁଲେସନ ସିଟ୍ ଟା ଫାଇଲ କରିଛନ୍ତି ତାକୁ କ୍ୟାଲକୁଲେଟର ରେ ପକେଇକି ସବୁ ଦେଖି ଦିଅନ୍ତୁ ଯେ ଠିକ ଅଛି ଏଇ ଅର୍ଡର ଏଇଟା ଡିପୋଜିଟ ଆପଣଙ୍କର ହବ କାଲି ରଖିବା ନା ନେକ୍ସଟ ୱିକ୍ ରେ ରଖିବା
So this is what I submit.
ଇଏ
That is a statutory interest manner. Maybe there is a
ଆପଣ
mistake in
ଚ୍ୟାଲେଞ୍ଜ
the
କଲେନି
order.
ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କଲେନି ଆପଣ କହୁଛି ଆପଣ ପ୍ରଥମରୁ କୁହାହଉଛି
I will file application before for clarification of that.
whatever you want to do
There is a statutory interest in all cases. The landlords have got interest
all right
similarly.
ଆମେ ଟାଇମ ଦେବୁ ଗୋଟେ ତା ଭିତରେ ଯାହା କରିବା କଥା କହ ହେଲେ କଣ
up to 30/12/2023.
Hmm.
In the meantime, more than 1 year.
ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ଆମେ ତାରି ଉପରେ ଅର୍ଡର କରିବୁ ତେଣୁ ବାକି ତାପରେ ଯାହା ହବ ସେ ଦେବେ ସେ ଲେଖନ୍ତୁ ଦିସ୍ ତ ହେଇଯାଇଛି ଅଲରେଡି ଅର୍ଡରଟା ପାସ୍ ହେଇଯାଇଛି ବଡ ଅର୍ଡରଟା the land council for the petitioner seeks for an adjournment to obtain instruction. You are land council for the opposite party. Land council for the opposite party number 2 Gordon. You are for Kishore Mani Mishra. Kishore Mani Mishra, opposite party seeks some time to obtain instruction from the said opposite party as to whether in terms of the proviso to section 28 of the Land Acquisition Act 1894 is to file an application before the senior civil judge Jharsuguda in LA case number 20 of 1991 for modification or not. Or to challenge the said order before the High Court. The matter will be commenced from here to the week.
Second item.
Second item also same. Only open number 2 and
party number 2. It WPC number 28160 of 2 and 3. And the matter will come together. Commencing for 17th February 2025. Yes.
interim order to continue.
Interim order to continue.
In the meantime, let them deposit the admitted dues. 87 acquisition ମାନେ କିଛି ପାଉନାହାନ୍ତି
ଆପଣ ପରା ସେଇଥିପାଇଁ କହିଲି ଯେ ସେଇ ଯୋଉ ଆନେକ୍ସ କାଲକୁଲେସନ ସିଟ୍ ଟାକୁ ଆପଣ ଟିକେ ଭେରିଫାଇ କରିଦିଅନ୍ତୁ ଆପଣ ସେତିକି ବି କରିବାକୁ ରାଜି ନାହାନ୍ତି 9% ଯୋଉଟା ଡିସ୍ପ୍ୟୁଟେଡ ନୁହେଁ ସେ ଟଙ୍କାଟା ତ କମ ସେ କମ ଆପଣଙ୍କ ବାକି ପାଇବେ କି ଅଧିକା ପାଇବେ କି ନାହିଁ ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର ସେଇଟା ଆପଣ କରିଦିଅନ୍ତୁ ଆପଣ ଦେଖନ୍ତୁ ତାଙ୍କ କାଲକୁଲେସନ ସିଟ୍ ଟା ଠିକ ଅଛି ନା ନା ହେଲା ୟେସ୍
Item 36.
Can I take the liberty? I think the bench is almost for 5 minutes. 36.
you will take 30 seconds.
Okay. No, that
30 seconds ଆପଣଙ୍କର କେତେ
Same method. 30 seconds.
30 seconds ଆପଣଙ୍କର
ନା ଆମର item 22 ଥିଲା ସେ ଭୁଲ ସେ non appearance ବୋଧେ ହେଇଯାଇଛି.
ଓହୋ ଏଇ ମ୍ୟାଟର ନୁହେଁ
No, that is the only thing that we both came rushing. We both were in the same court. So
just a minute. Item number
22.
22 का
You're not there.
22 pass over age.
We got to hear that.
नहीं pass over. Non appears लिखी दो बना. Yes. 36 टा
36 I have filed an application for imbue. The land in question.
which is that that is IN number 1395 of 2025. Let us see that application. Copy दे दीजिए. Any objection, Mr.
No,
Keith?
actually, I also wanted that this should be implemented as a party because I implemented the tourism
Ki
department.
ପକ୍ଷ ଅଛନ୍ତି
State is there.
14 annexures to your IA for impletion.
Yes, sir.
this just a minute. So Mr. Naik, so you must have received this copy of the
Yes,
interim application.
Right.
So the state is the only opposite parties, or
Yes,
there are
sir.
all the 1, 2,
Tourism
3,
department is there.
4, so 4, so 5. They all for
6,
you.
all government.
So do you have any objection, or will allow this? Allow. Lekun. IA number. Kete number sita 1395 of 2025. This application has been filed by Roots Corporation Limited. No? No, this has been filed by Mayfair Hotels and Resort with a prayer for being implicated as opposite party in the writ petition. The Land and Council for the state, so also the Land and Council for the petitioner has no objection to such prayer. Accordingly, the prayer is allowed. Mayfair Hotels and Resort Limited be added as opposite party number 7. So consolidated cost title to be filed by Friday. How come
This interim order of status quo is there.
what is the order dated 5/12/2024?
Yes, madam. Also looks at the order.
The interim order
5/12/2024.
interim order dated 5/12/2024 passed in IA number 16195 of 2024 shall continue until further orders.
Lord, may I make a small request? The Lordship called it the week commencing 17. Because my work has stopped. This land has been given to me by the government.
Okay.
And I've already constructed 70% of the work.
What a particular date kona hai?
17th, 18th, 19th, many dates.
See,
Mr. Mishra, any problem?
17, 18. I'll be absent on 19, 20, 21st, but I'll go on 18th. So if you're concerned 24, that will be better.
Either 17th, that will be late. My work is suffering.
No, 24.
11th, 12th, 11th, 12th.
Yes, 11th, 12th.
Is this matter on
11th.
11th? 11th of
Right.
February 2025. You consolidated title that file kale ତାକୁ ସେଟାକୁ ରଖିବେ
I'll file it by day after tomorrow.
ପୁଣାଟାକୁ କାଢିକି ତାକୁ ସ୍କାନିଂ କରିକି ରଖିବେ ତାପରେ ସିଏ ଥିବ
That has to be incorporated.
Request a copy of the writ petition to the sub-reference. Copy of the writ petition.
Sorry, the copy of the writ petition we sought on the newly implicated opposite party by Friday also. Yes, by Friday.
You want to file a counter affidavit?
Counter affidavit, if any, be filed in the meantime. No? From serving question. Great.
Supplemental list, item number 1.
May please go to the item 1 madam, on behalf of the district proprietor. Here, there is a I for condemnation delay madam.
What is the conviction?
Conviction madam. 302 120 B of IPC 201 34
How many days delay?
156.
What do you say? Delay will come down. IA number so and so, this is an application for condonation of delay. The stamp report has pointed out that there is delay of 156 days in filing this criminal appeal. After hearing the land counsel for both the parties and taking into account the grounds taken in the application for condonation of delay, and since this appeal is against the judgment and order of conviction in which life imprisonment has been awarded, they are inclined to condone the delay. Accordingly, delay is condoned, IA is disposed of, admit, call for the trial court record, interim application for bail and stay rise and fine to be considered after receipt of the trial court report. Position copy will be supplied to the land council for the state in the meantime. Yes.
Please publish.
Item 2.
Is it delay?
42 days.
And it is also a 302 case.
Yes, sir. JCRL already filed. So, that will 22.
Another appeal so and so is stands adjourned to so and so. Acha. Same appellant. Sunil Raut. In that JCRLA 198 of 2024, both the appellants are there or one appellant? JCRLA to Bharkala?
One of
Just a minute. Prisoner's petition. ଆପଣଙ୍କର prisoner's petition particular. That was Sunil Raut or Hembram. ଦି ଜଣ ଇଏ ତ ଅଛନ୍ତି ଆଚ୍ଛା JCRL ବାହାର କଲ ତ ଇଏ ସମ୍ରାଟ ସେଥିରେ ନଥିଲା ସେଟା କେବଳ ଫାଇଲ କରିଥିଲା ସୁନୀଲ ରାଉତ ଓରଫ ହେମ୍ବ୍ରମ ତେଣୁ ଏଟା ଆପଣ ଯେହେତୁ କ୍ରିମିନାଲ ଆପିଲ ଫାଇଲ କରିଦେଲେ ଦି ଜଣ ପାଇଁ ଫାଇଲ କରିଛନ୍ତି ନାଇଁ ସୁନୀଲ ରାଉତ ପାଇଁ କରୁଛି what about that Samrat has been acquitted of that? No, madam, we are asking a question. Two accused persons face trial. One is Sunil Rao, the other is Samrat Hembram. Now they face trial under section 302 and other offences.
one person.
What happened to that Samrat? Has he been acquitted? In the result, accused Samrat alias Swanso is held not guilty and acquitted. So only one accused left. So this JCRLA is to be disposed of because you have filed the regular appeal. So what order has been passed in that JCRLA? JCRLA is order passed.
Adjourned to 14/5/2025. I'm not engaged.
Saroj Kumar Rao. I have been invested. So now regular appeal has been filed. So this JCRL has to go. IN number so and so. This is an application CRL and condonation of delay. The stamp reporter has pointed out so and so jenti seta arata dapala ei type ro kari delay condon kar debe ye kar debe the registry has reported that it a JCRL record diyantu order ta kar diyantu it appears that the appellant has preferred separate appeal engaging counsel which has been registered as CRL number 4 of 2025 in which delay has been condoned on Sochansmanajika date and appeal has been admitted. Therefore, this JCRLA stands disposed of. 198 of 2024 disposed of.
Criminal appeal is ଗୋଟେ line ଥାଉଛି
ଯେ
related ଆମେ
criminal appeal ରେ ମଧ୍ୟ ଲେଖିଦେବେ. It appears that one so-and-so has been filed. Since we have already passed the orders in JCRLA number so-and-so, he said JCRLA shall not be listed henceforth along with this application. Are କିଛି ଅଛି interim application bail କରିବା ପାଇଁ ଅଛି, so that will be listed in after receipt of the trial date. Yes, next.
Item 3.
May please your lordships. Item 3, section 376D, your lordships.
Between lots of lots. It was pronounced in 12 442 and he is in custody since all right, you let him file objection. You file the 4400 like on IN number. So also there is an application for condonation of delay. The stamp reporter has pointed out that there is delay. Are you sure that it's a live conviction? No? Yes, live conviction.
Are
Are
you
you
sure no
sure
appeal
that-
file disposed of nothing?
Not this year.
No. देखिए dispose of time ହେଇଗଲାଣି 12 ବର୍ଷ.
अरे sorry ଟିକେ ମନ୍ଦିର
ରୁହନ୍ତୁ.
କୋଉ ଜେଲ ଏଟା ରିପୋର୍ଟ ମଗିବାକୁ ପଡିବ। ସେମାନେ ତାଙ୍କର କାମ ହଉଛି ପ୍ରତ୍ୟେକ ମାସରେ ତ ଏମାନେ ଯାଆନ୍ତି ଭିଜିଟ କରନ୍ତି ଯୋଉ ଇଏ ଆମର CGM ପ୍ଲସ୍ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ who conviction ହେଲା ଲାଇଫ ଫର ମାନେ 100% ଅପିଲ ଫାଇଲ
ଆପଣ ନଥିବ ହୁଏତ ସେ ଜାଣି ନଥିବ କିଏ ଫାଇଲ କରି ସରିଯାଇଥିବ appeal
କାରଣ ଯଦି ବି ଫାଇଲ ହେଇଥିବ ତାହେଲେ ରେକର୍ଡ ମଧ୍ୟ ପଳେଇ ଆସିଥିବ ଏଠି ଯଦି ଆଡମିଟ ହେଇଥିଲା ମାନେ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ ଆଚ୍ଛା ଲେଖି ଦିଅନ୍ତୁ ଦିଟା ତିନିଟା କଥା ଲେଖି ଦିଅନ୍ତୁ the jail superintendent it has furthered the high combination of delay you will file the objection the jail superintendent of Circle Jail Berhampur shall submit a report as to whether any appeal has been preferred from the jail by the appellant Ravindra Kumar Behera alias Hadia after he was against the impugned judgment and order of conviction dated 29/9/2012 passed by ad hoc additional session judge bracket first track court Chhatrapur in sessions trial number 52 of 2008. Stop. Out of paragraph. The official point out whether the appellant earlier appeal, public jail criminal appeal, whether the appellant has preferred any appeal or criminal appeal or public jail criminal appeal, challenging the judgment or not. Stop. Out of paragraph. A report be called for from the London trial court by the registered judicial as to whether the trial court record in sessions trial number so and so has been called for by this court in connection with any appeal, public jail criminal appeal or not. And free copy of the order be handed over to this one. So your part is to from the jail ଆପଣ obtain करिए. बाकी दीटा to ये करे है and तापरे यार delay condonation objection देबे हो.
Item 5.
May I please, Your Lordship, my Lord permit from the PC, Your Lordship.
Yeah.
My Lord, kindly list the matter after 1 week, Your Lordship.
Okay.
Madam, ଆପଣଙ୍କ ନାଁଟା କଣ?
My name is S.K.Sahoo, Your Lordship.
Someone behalf of
Sahoo on behalf of Mr. Amulya Ratna Panda, 6 for an adjournment. Put up this matter.
Obliged, Your Lordship.
Item 6.
Consider directly submit the custody report of the appellant number 2.
Appellant number 2, Babuli Sahu. You have filed the bail application for Babuli Sahu.
Hearing of the
Early hearing.
number 16.
Why custody certificate? Any bail application was filed?
Bail application, while rejecting the bail application, not for directed to produce the custody certificate so that that can be heard on.
Are you sure that no bail application is pending?
No, ma'am.
Okay.
The last bail application rejected is 8/10/2024.
नहीं ठीक है 8/10/24 रे order ହେଇଛି. We have rejected this one from finding chain. Then we have applied for interim bail from state. अच्छा कितने देखी कितने वर्ष लगा?
7 years, 1 month, 12 days as on 27.
7 years.
7.
Total period वाला. अच्छा. Paper book ready है ना?
Paper book is ready.
Copy पाई चल रही paper book. अपन पाई ही जल्दी. नियम तो receive कर दियो तो. February end आड़ो को बेटा को list करे दो बार. 2019 से तो जल्दी ही जाऊँगी. पुराना appeal सब रही थी. Till then, IN number 68 of 2025 is an application for early hearing. Learning counsel for the state has produced custody certificate dated so and so of the Superintendent District Jail Dhankana, which indicate that the appellant is in judicial custody for more than 7 years. Paper book has already been prepared. Land counsel for the appellant submit that he has received the copy of the paper book. However, the land counsel for the state submit that he is yet to receive the paper book. She is yet to receive the paper book. Matter the registry is directed to supply the paper book to the land counsel for the state. Matter be listed in the first week of the March. We commencing from so and so to the hearing district.
Madam Konadal.
Yeah, Nadal.
Ayushi Mehta on behalf of
Data book taken on record for the custody certificate.
Item 7.
May I please, Lordship? Lord.
Petition along with supplement applied with ଟିକେ ରୁହନ୍ତୁ 5B ଟା କଣ ଅଛି ଦେଖି The order was passed regarding the, he claims to be a juvenile.
Yes, Milord. Raju Maji was juvenile at the time of conviction.
No, why are you not filing any application, interim application? Where is your gown, Mr. Panda?
ଦେଖୁଛି
Business citizen
ବୀରେନ୍ଦ୍ର ମାଝୀ
ଏବଂ ଗୋଟେ order ତ ହେଇଥିଲା ବୋଧେ।
କନ୍ଧମାଳ ଦେଖିଦବା ହଁ ଏଇଟା ତ 1990 ହଁ ଗୋଟେ ଅର୍ଡର ହେଇଛି
I'm sorry, Milord.
Collecting date of birth ହଉଛି
ଫାର୍ଷ୍ଟ ଦେଖୁ ଫାର୍ଷ୍ଟ ତ ଖାଲି ହେଲା ହାର୍ଡ ଆଡମିଟ୍ 2020 ତାପରେ ତମ ସାଙ୍ଗରେ yoga
7/11/1990. Date of occurrence given
Date of occurrence is 13/4/2016.
13/2016.
Right.
Criminal of sick. Why are you not filing the application?
I have only filed the bail application for two brothers only.
Main ଜିନିଷଟା file କରୁନାହାନ୍ତି କଣ?
Yes.
Then inquiry is to be conducted.
19 years,
Once you file this, because the district child protection officer Kandhamal, a report is there that your date of birth is 7/11/1990. If the occurrence has taken place according to you is 13/4/2016. No, 16. Acha. 16 है तो हबनी 16. Are you sure?
It is evident from the judgment, Milord.
Judgment says 19 years.
No.
I get.
Now
We
23 years.
Date of occurrence होची 13/4/2016. So how can you be juvenile?
No. I should I place on merit, Milord?
You can.
Yes.
Your age is 1990 ମାନେ 10 plus 16 ମାନେ 16
26 ହେଇଯିବ।
25 ବର୍ଷ ଆପଣଙ୍କର ବର୍ଷ ମାନେ date of
କିନ୍ତୁ
occurrence ବେଳକୁ
ଆଧାର କାର୍ଡରେ ଅନ୍ୟ
now you can place on bail application. Okay.
Milord. In this case, both the appellants are two brothers.
So this interim application which you have filed,
That is not interim, that is the regular bail.
of 2023.
Yes, Milord.
This is for both the appellants.
Yes, Milord.
Okay, just a minute. So the A1 hela Virendra alias Ira Maji, A2 hochi Raju Maji.
Right.
Okay. So what is the date of custody? How many years you are in custody?
Both the brothers will likely 9 years.
You are on bail during trial?
No, Milord.
You are not on bail. So more than 9 years.
Yes.
So let us verify this and we'll proceed. Trial court record bar karun. Final form question. Final form is your date of custody. अच्छा ଦି ଜଣଙ୍କର ହଉଛି ଗୋଟେ ଡେଟ୍ ହଁ 24/4/2016 ପାଇଲେ ଫାଇନାଲ
ନା ମୁଁ ଏଇଠୁ ଜଜମେଣ୍ଟ ରୁ ପାଇଲେ କୋଉ ଦିନ ଆରେଷ୍ଟ କରିବି
ହଁ
24/4/2016
ଲେଖାଇବି ଫାଇନାଲ ଫର୍ମରେ
ହଁ
କ୍ଲିକ୍ କରିଦେଲେ ପଳେଇ ଆଉଛି ଡେଟ୍ ଆଣ୍ଡ ଆୱାର ଟିକେ
ମୁଁ ଆଉ
ଆଚ୍ଛା ସେ then you are not on bail during trial.
Yes, I was not. Both the brothers who happens to be the appellants in this case, we are not on bail.
UTP, accused persons produced. No.
memo of arrest ବି ଅଛି
memo ନା trial court ର bail ଥିଲେ କି
ଆଚ୍ଛା ଆଚ୍ଛା
ସେଥିପାଇଁ ସେଟା order sheet ହିଁ ଜଣା ପଡେ
ହଁ
so always they are produced
order sheet ତାପରେ ଯୋଉ remanded to custody
ତେଣୁ ଏଇଠୁ so you are not released on bail means you are in custody for more
yes,
than
from the date of arrest.
ହଁ date of arrest ହେଲେ ଆପଣଙ୍କର ହଉଛି 8 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଇଯାଇଛି
9 ବର୍ଷ ଏପ୍ରିଲ କୁ ହବ 23/4/16
ଯୋଉଟା
23/4/25 ସରି
8 ବର୍ଷ 9 ମାସ ହେଇଛି ତ
ଆଜ୍ଞା 10 ବର୍ଷ ହେଇଛି
ତ 8 ବର୍ଷ 9 ମାସ ହଁ ବାକି ନେକ୍ସଟ ହଉଛି what is the name of the deceased?
ଡୁଲୁ ମାଝୀ
judgment ଆଣ judgment Dulu
DULU.
Please read the paragraph number 2 of the judgment.
Yes, Lord. The case of the prosecution in brief is that on 13/4/2016, the informant Bipin Majhi went to Belghar weekly Wednesday market. At the market, he met his nephew Dulu Majhi, the deceased, at Belghar market. At about 5 p.m., both of them returned from market together and headed to their village. On the midway at Jalipoda Chowk, they parted from each other and went to their respective villages. 2 days thereafter, the informant visited the house of Dulu Machi. At his house, informant came to know that the deceased Dulu Machi was missing from his house since evening hours from 13/4/2016. From his inquiry, informant came to know that at about 8 p.m. of 13/4/2016, Birendra Maji and his younger brother Raju Maji severely assaulted Dulu Maji. The accused Birendra Maji crossed the head of Dulu Maji with a stone. They cut neck of Dulu Maji. They killed him and buried him at a nearby jungle. On 23/4/2016, informant lodged a report to that effect before the OIC Belghar PS. The OIC Belghar PS registered this case as PS case number 17 by 2017 dated 23/4/2016 and took up investigation of this case. During course of investigation, the IO arrested the UTP's accused persons on 24/4/2016 and forwarded them to the court.
Eyewitness to the occurrence?
PW number 10 and 15.
PW 10 and 15.
Yes, page number 77 and 84 of the paper.
Eyewitnesses. Who is the doctor who conducted PM?
Yes, PW 17 Miller. PW 17 named Dr. Vishwanath Murmu.
PM. आगे पढ़े आसुन तो PW 17.
आगे.
अच्छा मुंडा टोटल अलगा
आगे
अच्छा वर्तमान पढ़े आसुन जो ठीक है एविडेंस ऑफ PW 10
yes 77 yes
part which paragraph number 2
yes the occurrence for which I am deposing today took place on one Wednesday. On that night I was standing near my house A verbal duel took place in between Virendra and Dulu. Virendra pushed Dulu. Dulu fell down on the ground. Virendra crossed a stone on the Dulu. Hit at the head of Dulu. Raju came with a knife and cut neck of Dulu. They separated the head of Dulu from his body. Both of them took the dead body of Dulu to Malagu jungle by dragging the dead body. They buried the dead body of Dulu in that jungle.
So what happened to that second one? जे आज ये काटिला बेको कौन था ना
Tanala Raju Majhi, who happens to be the younger brother of the present appellant.
की पड़ गला सी तो ट्रायल फेस कोन थला
See अच्छी जेल
कोन अच्छी अच्छी ट्रायल फेस बोला
आगे
both
करी
of them have been found guilty अच्छा
yes yes
okay so the eyewitnesses have also stated that
yes sir
how the assault took place and how
yes
you caught the neck
yes ma'am
decapitated
ये decapitated
what
because of that is profuse hemorrhage due to decapitation of head
कौन कौन कहिवे
से एथिरे मेंसिरिया नाही ताकर
ଆପଣ ଆଇ ୱିଟନେସ୍ ଦି ଜଣ ଅଛନ୍ତି it is corroborated by PM
again all of sudden they started a quarreling with each other
ଗୋଟାକୁ କାଟିଦେଲେ ଆଉ ପୁରା ଅଲଗା କରିଦେଲେ ନା ଆପଣ ପେପର ବୁକ୍ ବି ହେଇଯାଇଛି
ଆଜ୍ଞା
କିନ୍ତୁ ଶୁଣାଣି ପାଇଁ
ଆଜ୍ଞା
learning counsel for the appellant learning counsel for the state in view of the eyewitnesses account of PW10 and PW15 coupled with the evidence of PW17 the doctor who conducted postmortem and find that the he head was found to be decapitated from the body and the skull was crossed to multiple pieces. We are not inclined to release the appellants on bail. Stands rejected. Paper book has been prepared. The matter be added to the hearing list in due course. Yes.
Finally, the hearing should be made after 4 weeks.
The name of other counsel, amicus curiae, shall not be reflected in the cause list transfer. Yes, next.
Item 8.
Conduct certificate produced.
State to
You have to produce. They learn counsel for the state. 6 some further time to produce this conduct produce the report from the concerned IIC regarding the conduct of the petition filed on interim date. Put up this matter 2 सप्ताह पर yes next
Item 9.
यदि पठेना the reminder पठे दे हला
Given on the section 3 IPC and 3 years for 201 IPC. So there is no IPC occurrence.
Just a minute. Mr. Pradhan, you have received the deposition copies. Deposition copy देना है? दियो the Learned Counsel for the appellant handed over the deposition copies to the Learned Counsel for the state in court today. Please this matter next week. Okay? We commencing from 3rd February.
Item 11.
So paper 1 week after.
कौन है जी paper?
Lordship, paper 1 week
अच्छा,
after.
1 week after. You have received the deposition copies? You have received the paper. Got it. Mentioning, what is your good name?
Rajabhushan, sir.
You have no power in this case. अच्छा, Brajabhushan Sahu. All right, Mr. B.B. Sahu, Land Counsel for the appellant, 6 for an adjournment. Place this matter 10th of February 2024. 2025. Yes.
Item 12.
Yes.
Well, the Lordship directed whether any state has referred.
वो तो पाठ है किला ना पेपर
Item number 6. Last occasion, you got the directed to get the decision that the important fact has been omitted, which affect the probabilities of the case, regarding section 11 of the Evidence Act. I have brought this decision.
या धीरे इतला जितबले देले इतलारे ए जो लाइन्स गुडा को कहिले जे इतलाकारी होची PW10 PW10 होची ब्रदर ऑफ द डिसीज श्रद्धांजलि पात्र ଏବଂ ସିଏ କହୁଛି ଯେ 21/11/2010 ତାରିଖରେ ସମୟ 4ଟା ସମୟରେ ବାହାର ଲୋକଙ୍କ ଠାରୁ ଫୋନ ପାଇ ଜାଣିଲି ଏବଂ ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ଗୁରୁଡଝାଟିଆ ଗ୍ରାମକୁ ଆସି ଦେଖିଲି ଯେ ମୋ ଭଉଣୀ ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ମୃତ ହୋଇ ପଡିଥିବାର ଦେଖିଲି। ମୋର ଭଉଣୀର ଶାଶୁ ମଲ୍ଲି ଦାସ, ସ୍ୱାମୀ ସୁରେନ୍ଦ୍ର ଦାସ ଓରଫ ବାପି, ସୁରେନ୍ଦ୍ର ଦାସ is the appellant here, ନଣନ୍ଦ ରୀନା ଦାସ, ଦିଅର ମୁନା ଦାସ, ମଳାସୁର ଅଗ୍ରା ଡାକନାମ ସାନ ଶ୍ୱଶୁର ଓ ପରିବାର ସଦସ୍ୟ ମିଳିତ ଭାବରେ ଶାବଳରେ ପିଟି ପିଟି ମାରିଦେବାର ଜଣା ପଡୁଅଛି। ତାଙ୍କ ଦେହରେ କୌଣସି ଅଳଙ୍କାର ନାହିଁ। ମୋର ଭଉଣୀ ଶୋଇଥିବା ବିଛଣା ରକ୍ତ ଜୁଡୁବୁଡୁ ହେଇଛି। ମୋ ଭଉଣୀକୁ ନୃଶଂସ ନିର୍ମମ ନିଷ୍ଠୁର ଭାବରେ ମାରିଥିବାର ସ୍ପଷ୍ଟ ଜଣାପଡେ। So this is the story which he has narrated in the FIR. So that is why the FIR was also registered against as many as 7 persons. Okay.
Family members.
But in the trial, the witness has stated that the present appellant made extrajudicial confession that he has assaulted by means of a crowbar to the deceased, right?
Yes.
That is PW10. The line of asile
PW10 brother.
extrajudicial confession is ma ko pachar. That is page number 54. Page number 54, paragraph number 3. This is the informant PW10. And he has stated that when I asked the matter to the mother of the accused, she told me that her Surendra assaulted Shraddhanjali by means of a crowbar.
The FIR registered 10:30 p.m.
So the submission was
after knowing the fact the FIR scribe be examined.
So if this fact was disclosed to PW10 by the mother of the appellant that her son, that means the appellant assaulted Shraddhanjali by means of a crowbar which resulted her death, it should have been mentioned in the FIR.
Yes.
Rather in the FIR that is not there. In a general manner it is stated that samaste taku milimisi piti piti markare. Say 75 Supreme Court decision and on the
paragraph
paragraph relevant. Dita copy ଦେଇଛନ୍ତି ନା ଗୋଟେ ଦେଇଛନ୍ତି?
Paragraph 9 ରେ ଦେଖିଲେ ଯେ we think that omission of such important fact.
Wait. 1026.
Paragraph 9 Lord.
Paragraph 9.
Last but third line.
मैं पूरा तो पढ़ना नहीं paragraph.
No doubt, an FIR is a previous statement which can strictly speaking be only used to corroborate or contradict the maker of it. But in this case, it had been made by the father of the murdered boy to whom all the important facts of the occurrence, so far as they were known up to 9:15 p.m. On 1970, were bound to have been communicated. If his daughters had seen the appellant inflicting a blow on Harvinder Singh, the father would certainly have mentioned it in the FIR. We think that omissions of such important facts affecting the probabilities of the case are relevant under Section 11 of the Evidence Act in judging the veracity of the prosecution case.
तामने informant को एया जदि हेई थांदा तले informant केबे मिस करना थांता एते बड़ा information दा आउ से एमिति लेखना थांता जे समस्या ताकू मिलीमिशी इटिबिटी मार देले. If the information was given by the mother of the appellant that the appellant assaulted the so and so. Now, how many the charge was framed only against, because charge sheet was not filed against the other accused persons. Only this man was, though the FIR was lodged against 7 persons, but charge sheet was filed only against this man. So apart from that particular statement that the ମା କହୁଥିଲା ଯେ ତାକୁ ଶାବଳରେ ପିଟି ଦେଲା, ଆଉ କଣ ମ୍ୟାଟେରିଆଲ ଅଛି?
ଆଉ ହଉଛି ଲର୍ଡସିପ ଅନ୍ୟମାନେ ତ ସବୁ ଯୋଉ ହୋଷ୍ଟାଇଲ
Hostile
ହେଇଗଲେ
ହେଇଯାଇଛି।
ସେଇଟା ସେ କହିଥିଲେ ଯେ ତାର ଇଲିସିଟ ରିଲେସନସିପ ଅଛି ବୋଲି ସେ ଶୁଣିଲା, ତାକୁ ସେଇ ବିଷୟରେ ପଚାରିଲା ବୋଲି ସଡନ ପ୍ରୋଭୋକେସନ ରେ ସେ କ୍ୱାରେଲ ହେଇଛି ଆଉ ମାରି ଦେଇଛି ବୋଲି ଏଟା ସେମାନେ ଡିକ୍ଲାଇନ କରିଛନ୍ତି, ତେଣୁ ସେଟାକୁ ଆଉ ମୁଁ କହୁନି। ଆଉ ସେକେଣ୍ଡ ଜିନିଷ ହେଲା ଲର୍ଡସିପ ମେ ସି ଦି ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ ୱାଜ seized on the next day immediately after the occurrence, my lord. And
No,
that
the,
was
you on that day also you placed the evidence of PW9, I think,
yes,
who has
yes.
stated that
Mamu, sister Mamu.
ସେ କହୁଛି ତାଙ୍କ ସମ୍ପର୍କ ଭଲ ଥିଲା ନା କଣ,
ଭଲ ଥିଲା।
ଖୁସିରେ ରହୁଥିଲେ।
ସେ ବି କହିଛି 10 PW10 ବି କହିଛି ଯେ ଆମ ଘରକୁ ବି ବୁଲି ଆସିଥିଲେ, he was happy.
ଆଚ୍ଛା, PW10 ହଉଛି
Brother.
ତାର ଭାଇ। ହଁ, ଏଟା ମୁଁ underline କରିଥିଲି। Paragraph number 5 ରେ accused along with my sister had been to our house only once after the marriage, and at that time both accused and my sister were living happily. ଏଟା ହଉଛି PW10 ର evidence। ତାପରେ PW9 ମଧ୍ୟ କଣ ଗୋଟା କହିଛି।
torture କରିଥିଲା ବୋଲି
ଆଚ୍ଛା, ସେ ଯୋଉ Khajia Naik was the mediator of the so and so.
ଖଜା ନାୟକ ଟା accused ହେଇନି ଆର କେସ ରେ ଯୋଉ 498 ରେ।
No, Khajia Naik is not a witness. He suppose there was any demand, অবশ্য এর কি charge নাই, মানে mediator was supposed to know the same. ତେଣୁ Khajia Naik was a witness in the charge sheet, but he has been declined.
ଖଜା ନାୟକ ଟୋଟାଲ ଆସିନି, ସେ ପ୍ରିଷ୍ଟ ଟା ଆସିଥିଲା ପାକୁଆ।
Similarly, this mother was also an a witness also, and she was declined by the prosecution. Notices the summons were issued to her, and she appeared and declined memo. Perhaps after testing the witness, the public prosecutor found that he is not to support the prosecution case. That might be the reason why, and after all, she is the mother. ତେଣୁ ସେଥିପାଇଁ ଆଉ କଣ ରହିଲା, ଏଭିଡେନ୍ସ କଣ ରହିଲା?
ଆଉ ଏଭିଡେନ୍ସ ରେ ବି ସେ ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ ପଠେଇଲା 4 ମାସ ପରେ ଯୋଉ କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ତାର ରିପୋର୍ଟ ଆସିନି, ସେ ଜଜମେଣ୍ଟ ଲେଖିଦେଲେ।
କେମିକାଲ ଏକ୍ସାମିନେସନ ରିପୋର୍ଟ ତ ଆସିନି, ଆଉ କଣ?
Delay in sending the material object for chemical examination, my lord.
It's all right. Now, suppose C report ରେ ଆସିଥାନ୍ତା, ଆପଣଙ୍କର against କିଛି ଥାନ୍ତା, matter would have been different. ଏଠି C report total ହିଁ ଆସିନି, ତେଣୁ ବାକି
ଠିକ ଆସୁନି, sudden provocation so good.
So, Mr. Naik, your initial case was that there was torture, there was demand of dowry, and there was assault by the in-laws family members by crowbar, for which 7 persons were named in the FIR, right? And but after the investigation was over, the IO found that neither there is any material for 498A, nor there is any material for the other offense, that is 304B. under which the FIR was registered. So he only submitted charge sheet under 302, right? And so far as the other accused persons who have been named in the FIR, they were also not charge sheeted. So that remains same. Now, it's a case based on circumstantial evidence. So if it is a case based on circumstantial evidence, what are the circumstances you have proved against this appellant to show that the chain is complete and there is no escape from the conclusion that he is the author of the crime? He was living in a joint family. This deceased was living in a joint family, and the allegations are also there in the FIR that all were torturing, all have assaulted. So that is the allegation. And so far as torture is concerned, the brother has stated that once they had come and there was good relationship between them, and demand of dowry is not proved or nothing, or no charge also there. Now only material is that particular statement which has been given by the mother of the accused, mother of the appellant, that the appellant dealt blow by crowbar. Now, if that is the only material and that was given by the informant, then if that is not there in the FIR, rather it is the FIR, it is stated that all the family members assaulted by crowbar, then how it would be acceptable in view of this ratio laid down in the Supreme Court, that it was otherwise relevant if it is think of it that informant who accused ର ମା କହୁଛି ଯେ ମୋ ପୁଅ ତାକୁ ଶାବଳରେ ପିଟିକିନି ମାରି ଦେଇଛି, ତାପରେ ସେ ଯାଉଛି ଏତଲା ଦବାକୁ। ତ ଏତଲାରେ କହୁଛି ଯେ ତାଙ୍କ ଘର ଲୋକ ସମସ୍ତେ ମିଶି ଶାବଳରେ ମାରି ଦେଇଛି ହେଲା। ତେଣୁ ସିଏ ସେଠି କହୁନି ଯେ ତା ମା କହିଲା ଇଏ ଶାବଳରେ ପିଟିଦେଲା। ତେଣୁ ଏଇ ଯୋଉ ଷ୍ଟୋରିଟା ପ୍ରଥମ ଥର ପାଇଁ ସିଏ ଆସି କୋର୍ଟରେ କହୁଛି, ଯୋଉଟା କି ଏତଲାରେ ନଥିଲା। So how that would be a ground to convict a person in an offense under section 302 if this is the only circumstance?
Apart from that matter, there are three hostile witnesses there. There are P-double 5, 6 and P-double 7. I place that hostile witness.
What is there in that?
Is the co-villager of the accused. P-double 5, page 41.
P-double 5, yes.
I know the accused Surendra Das. I do not know the informant. Accused Surendra had married in the village of Polsapur in the last year in the month of Asada. After the marriage, his wife was staying in the house of the accused Surendra. Occurrence took place on 7 to 8 months back in the house of the accused Surendra. After 6 to 7 days of occurrence, I came to my village and I had been outside my village. I heard that wife of accused died. I was not examined by the police. At this stage, none had put some question of this cross again. It is not a fact that hearing the cry of the wife of this Sanatan.
এসব মনা করছি।
Last paragraph লেখা আছে reached the spot and wife of Sanatan was wiping, and that wife of Sanatan told me that her son is running away after the assaulting to the of his wife by crowbar, and that we all saw the accused Surendra is running away by the
It's not a fact which right ସତ ନୁହେଁ, ସେ ତ ଗୋଟେ ସଜେସନ ଦଉଛି ଯେ ଏମିତି ଏମିତି ଘଟଣା ହେଲା। ତାହେଲେ ଏଇ ଏଭିଡେନ୍ସ ଟା ଆପଣଙ୍କର କୋଉ ୱେରେ ହେଲ୍ପଫୁଲ କରିବ? ଗୋଟେ ୱିଟନେସ୍ ଆପଣଙ୍କର କେସ୍ କୁ ସପୋର୍ଟ କଲାନି, ତାକୁ ପ୍ରସିକ୍ୟୁଟର ସଜେସନ ଦେଲା ଯେ ଘଟଣାଟା ଏମିତି ହେଇଛି, ସେ ମନା କଲା। How this evidence would be relevant and will be taken into account? ସେ ଯଦି କହିଥାନ୍ତା ହଁ ଘଟଣାଟା ଏଇ ଟାଇପ ର ହେଲା ବା ପୋଲିସ ପାଖରେ ମୁଁ ଏଇଆ କହିଥିଲି, that's a different matter. ଏଠି ସିଏ କିଛି ଘଟଣା ବିଷୟରେ ଟୋଟାଲ କିଛି କହିଲା ନାହିଁ। ଖାଲି କହିଲା ଯେ ବାହାଘର ଏମିତି ହେଇଥିଲା, ସିଏ ରହୁଥିଲା ତା ଶାଶୁ ଘରେ, that's all. ଆଉ prosecution ତାକୁ ଏଇ type ର ଗୋଟେ suggestion ଦେଇ ଚାଲିଗଲା.
The evening hour, while I asked the accused, he told that his wife is indecent relationship.
These are all the suggestions given.
That's
Are you not fast to Aramba? It is not a fact
my lord.
that hearing, that means the suggestion has been given. The suggestion ଏଇଆ ଦେଇଥିବ, ଦେଖ ସନାତନର wife ର ଯୋଉ ଚିତ୍କାର ହେଲା ତାକୁ ଶୁଣିକିନି ତମେ ଯାଇକିନି ସେ ଘଟଣା ସ୍ଥଳରେ ପହଞ୍ଚିଲ ଏବଂ ସେଠି ଦେଖିଲ ସନାତନର wife କାନ୍ଦୁଛି ଏବଂ ସିଏ ତମକୁ କହିଲା ଯେ ଶୁଣାନ୍ତୁ ସେ ମନା କରୁଛି, କହୁଛି ନାଇଁ ଏଗୁଡା ଠିକ ନୁହେଁ ଏମିତି.
And the Schedule 7, they are stating that it is a fact that they are also hostile witnesses, page 36.
Just a minute. Yes.
Page paragraph 5, my lord. The fact that I had not stated before the police that I had been to the house of the accused and found mother of the accused was a weeping and wife of the accused was lying on the court with the
ତା ମାନେ କଣ? ଇସି ମାନୁଛି
my lord,
ଯେ ମୁଁ ଏଇଟା ପୋଲିସ ପାଖରେ ଏଗୁଡା କିଛି କହିନି,
my lord.
ଏଗୁଡାକ ପୋଲିସ ପାଖରେ କହିନି ଯେ ମୁଁ ଯାଇଥିଲି ଆକ୍ୟୁଜ ଘରକୁ ଏବଂ ଦେଖିଲି ତା ମା ସେଠି କାନ୍ଦୁଥିଲା ଏବଂ ତାର wife of the accused was lying on the cot with profuse bleeding and mother of the accused told us that the accused so and so. ସିଏ ମନା କରିଦଉଛି ମୁଁ ଏଗୁଡା କିଛି କହିନି ବୋଲି, ହେଲା. It is a fact that I had not stated. ଏଠି chief examination ରେ ସେଗୁଡା କିଛି କହିଥିଲା କି?
Reached the spot and found the mother of the accused. Surendra was waiting and we found his wife of the Surendra lying on court to full blood. The blood was pouring out from the head of the deceased. The mother of the accused told us that her son Surendra killed his wife. Police had been to the spot and prepared the inquest report of the dead body of the Sadhanbari. I had put my sign on this inquest report.
So ଯୋଉ ଜିନିଷଟା ସେ chief examination ରେ କହିଲା, ସେ କହିଲା ଯେ ମୁଁ ଏଗୁଡାକ ସବୁ ପୋଲିସ ପାଖରେ କହିନି, ତା ମାନେ କଣ ଉଦ୍ଦେଶ୍ୟ, ମାନେ ଆଣିଲେ ସେ କଣ ଯେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ କହିଲେ 161 ରେ ନାହିଁ, for the first time ଆସି କୋର୍ଟ ରେ କହୁଛି, ସେଇ ଜିନିଷ ହିଁ ଏତଲାକାରୀ ବି ସେଇଆ, ଇଏ ବି ସେଇଆ. ତା ମାନେ ପ୍ରଥମ ଥର ପାଇଁ ଆସି ଆପଣଙ୍କର କେସ୍ ହଉଛି ପ୍ରଥମଷ୍ଟୁ ଗୋଟେ ଅଲଗା କେସ୍, ଯେ ସମସ୍ତେ ନିର୍ଯାତନା ଦଉଥିଲେ, ସମସ୍ତେ ତାକୁ ମାରିଦେଲେ ଶାବଳରେ, ହେଲା. ଏ ଜିନିଷ ଆପଣ ଟ୍ରାଏଲ ଷ୍ଟେଜରେ ଆସି ଡେଭଲପ କରୁଛନ୍ତି ଯେ ସେ ତା ମା କହିଲା ଯେ ଗୋଟେ ଶାବଳରେ ମୋ ପୁଅ ପିଟିଦେଲା. ତ ଏଇଟା ଯେତେବେଳେ ପ୍ରଥମ ଥର ପାଇଁ ଆସି ଟ୍ରାଏଲରେ କହୁଛନ୍ତି, ଯୋଉଟା କି ଆଗରୁ ଆପଣଙ୍କର FIR ରେ କେସ୍ ନାହିଁ କି ଆପଣଙ୍କର 161 ରେ କେସ୍ ନାହିଁ, ସେଇ ଏଭିଡେନ୍ସ କୁ କେମିତି ଆକ୍ସେପ୍ଟ କରାଯିବ, ସେଇଆ ହିଁ ପ୍ରଶ୍ନ ଆପଣଙ୍କୁ ହଉଛି. ସେ how that evidence will be accepted and he will be convicted. When a witness comes for the first time during trial, tells something, ହେଲା. ଆଉ ତାପରେ ମାର କହିବାଟା ସେ ମାକୁ ଆପଣ ଯଦି ଏକ୍ସାମିନ ନ କଲେ ସେଟା ହିୟର୍ସ ଏଭିଡେନ୍ସ ହେଇଗଲା, ସେଇଥିପାଇଁ ମାକୁ ସେ ଚାର୍ଜସିଟ୍ ୱିଟନେସ୍ କରିଥିଲା. He was a charge sheet witness. He was also summoned. He appeared and the witness, he has been declined. We have verified it. The public prosecutor has declined it to examine the witness. ତେଣୁ that would be hearsay evidence. ଯୋଉଟାକୁ it would be hit by section 60 of the Evidence Act. ଯାହାଠୁ ମୁଁ ଶୁଣିଲି, ମୁଁ ରାମଠୁ ଶୁଣିଲି, ତାହେଲେ ମୋର ନିଜର କିଛି ବ୍ୟକ୍ତିଗତ ନାହିଁ, ଜ୍ଞାନ ନାହିଁ, ମୁଁ ଶୁଣିଲି ରାମ, ହେଲା. ତ ରାମ must be examined and he must say that yes, I have the knowledge and also I have told to X, then that will be admissible. Otherwise ମୁଁ ଯଦି କହିଲି ମୁଁ ରାମଠୁ ଶୁଣିଲି, that is not admissible, that is hearsay evidence. ମୁଁ ଶୁଣିଲି କଥା ହଉଥିଲେ सी ताकू मारदेला दैट्स हियर्स एविडेंस हैला तो जाटू सुनिली तार कौन ज्ञान अछि व्यक्तिगत ज्ञान ए विषय रे हैला सी तार ज्ञान थिबा दरकार हैला एवं से कहिथिबो जे मु आकु कहिली ताहले गोटा लिंक कंप्लीट हबो एवं दैट वुड बी एडमिसिबल अदरवाइज इट वुड बी हियर्स एविडेंस to when your witness says that they have heard it from the mother of the accused and the mother of the accused has not been examined. So it is a hearsay evidence, right? And moreover that it was not your case right from the beginning. Your case is something different. All have assaulted by crowbar. Now you are confining to only a particular person during trial and that to giving a hearsay evidence. So it is 302 रे how far it would ଆଉ କିଛି ତ evidence ନାହିଁ ଯଦି ଭଲରେ ଚଳୁଥିଲେ ତା ଭାଇ କହିଲା ସେମାନେ ଆସିଥିଲେ ଖୁସିରେ ଥିଲେ ଆଉ ତାପରେ it is not a case ଯଦି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହଁ ଗୋଟେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମନେକର ଏକୁଟିଆ ଗୋଟେ ଘରେ ରହୁଥାନ୍ତୁ ହେଲା ତାହେଲେ ସ୍ୱାମୀକୁ explain you say that ଯେମିତି ଯୋଉ ଆଗ ପୂର୍ବ କେସଟା ଆମେ ଯୋଉ ବେଲ ଶୁଣୁଛୁ ବଟ୍ ଏଠି ଗୋଟେ ଆପଣ ଏଣ୍ଟାୟାର ଫ୍ୟାମିଲି ଲୋକ ସବୁ ରହୁଛନ୍ତି ଯୋଉମାନଙ୍କ ନାଁରେ ମଧ୍ୟ ଆପଣ ପ୍ରଥମରୁ ଅଭିଯୋଗ ଆଣିଛନ୍ତି ତେଣୁ ଏଠି ଆପଣ କେମିତି କନଫାଇନ୍ କରିଦେବେ ତାକୁ ଏଇ ଟାଇପର ଏଭିଡେନ୍ସରେ ଆଉ କିଛି ଅଛି ନା ନାହିଁ ସେତିକି सी रिपोर्ट तो प्रोड्यूस कलेनी विटनेस वाइटल विटनेसेस गुड़ा को काटी देले अपन एग्जामिन कलेनी आपनकर जो यौतुक निर्यातना गोटे मोटिव रहिबा कथा सेटा भी इट वाज नॉट फाउंड टू बी करेक्ट फॉर व्हिच चार्ज शीट वाज आल्सो नॉट फाइल्ड अंडर 498 304 बी 4 डीपी एक्ट रे मध्ये केस रजिस्टर्ड हेतला तेणु सेगुड़ा सब काटी दिया गला केवल हाँ आउ गोटे लाइन अच्छी that is also most important I perhaps that whatever we received by way of jimanama eta ame nijo khushi re deithilu that is then page number 55 that is most important somewhere here stating page 55
last
no koda line
last 4 line
that is page 55 whatever we received from the police as per jimanama we gave those articles to my sister out of love and affection ये जो लाइन का रोची हैला तुम एटा डिमांड कोठ आसी बटी तो अंडरलाइन में कराई छी yes no यदि it was a case of presentation by way of love and affection so it cannot come within the definition of dowry and that is the reason why perhaps this TP Act, this 304B, those are all dropped. And 498 obviously जो type of statement आसिलानी जे accused आसितला एवं समाने बहुत खुशी रे रहुतले Come to another important line, page 61%. Page number 61, paragraph number 7. This is the IOS evidence. I examine PW10. ये कहूची ना माँ to सुनीला बेली. You come to the last
10 and his uncle Dibakar
no. I can't. And that charita line तोड़ू आना. Page 61 paragraph 7 charita line तोड़ू. And that he asks the mother of the accused and that accused assaulted to his sister by means of crowbar. बुझिले ये जो statement पुलिस पहला जे मो पाखरे उडा किछि कहि नथिला तामाने 161 and 9 FIR and 9 first time आसी कोर्ट रे कहूछि कहूनी ऊपर it is a fact I examine PW10 अमूल्य पात्र it is a fact that PW10 has not stated before me so से सब कहूछि जे ता मां को पचारली मां कहला जे पुओ
10 and his uncle Dibakar Prasad had gone to the house of the accused to settle and that on
बढ़िया
Dibakar had been to the house of the deceased with him
and that would
he
lage
asked the mother of the accused that the accused assaulted to his sister by means of crowbar.
हैला मां को पचारली मां कहला जे accused assaulted this was also not there stated before the police so this is the evidence how that guidelines which is in that Panchashield which is there in that Sarda Brichans the case ro jo panchota jo कहइचंती circumstantial evidence रो जो principle हबो एई जो गोटी evidence जोटा कि प्रथम थर पई कहइचंती कोर्ट रे आसीगिनी या बेसिस रे अपन केमती कहबे चेन टा कंप्लीट हे गला Lennon trial court came to hold that it is a case based on circumstantial evidence and relying on the evidence of PW2 PW5 PW9 and PW10 came to hold that there was sufficient evidence to show that the appellant and the deceased were last seen together, and the accused has not offered any plausible explanation about the cause of death of the deceased. The Lennon trial court also placed reliance the leading to discovery of the crowbar at the instance of the appellant and further held that since the appellant has not discharged his burden as per section 106 of the Evidence Act, there is a complete chain of circumstantial evidence which lead to the only inference of the guilt of the appellant. And therefore, the appellant was held guilty under section 302 of the Indian Penal Code. With Susmita Nanda, Lennon counsel, appearing for the appellant, contended that from the very inception of the case, the prosecution has tried to make out a case of dowry demand, torture to the deceased in connection with demand of dowry,
and also assault by all the family, in-laws family members, including the appellant, by crowbar, for which the case was registered under section 498A 302 304B by 34 IPC and section 4 DP Act. However, during course of investigation, it was found that there was no material to support the accusation under section 498A 304B by 34 of IPC and section 4 of Dowry Prohibition Act, and also the accusation against the co-accused persons who are named in the FIR. And that is the reason, while submitting the charge sheet, the IO deleted the names of the co-accused persons, also deleted the offences under section 498A 304B by 34 IPC and section 4 DPR, and charge sheeted the appellant only under section 302 of the Indian Penal Code. The Land Council further submits that the prosecution case is based on circumstantial evidence, and the circumstances have not been established firmly, and important witnesses have been withheld by the prosecution, even though they are charge sheet witnesses, and evidence further reveals that the deceased and the appellant were living happily after the marriage, and for the first time in court, a case has been presented that it was on account of the crowbar blow given by the appellant to the deceased, she died. The Land Council further argued that there are material on record to show that whatever articles were given at the time of marriage were not dowry articles, but it was given out of love and affection. And since the so-called statement of the mother of the appellant implicating the appellant in the assault of the deceased is not there in the first information report, not there in the 161 CRPC statement, but deposed for the first time, no reliance can be placed on the same. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. She placed reliance in the case of Ramkumar Pandey versus State of Madhya Pradesh, reported in AIR 1975 Supreme Court 1026. Stop. Mr. Jateshwar Nayak, an additional government advocate, on the other hand, supported the impugned judgment and submitted that the death of the deceased has been proved to be homicidal in view of the evidence
given by PW1. And since the appellant was in the company of the deceased, he was required to discharge his burden as to under what circumstances the deceased met a homicidal death in view of the provision under section 106 of the Evidence Act, which the appellant has failed to discharge. The Land Council submits that the evidence of PW9 and PW10 are very relevant, as they have stated that when they visited the house of the appellant, getting the news of death of the deceased, they found the deceased lying on the cot, and the mother of the appellant disclosed before them that it was the appellant who dealt crowbar blows to the deceased, resulting her death. And therefore, the Lenin trial court has rightly placed reliance on the evidence of these two witnesses. It is argued that the manner in which the death has taken place and the evidence on record, there is nothing to interfere with the impugned judgment, and therefore the JCRLA should be dismissed. Adverting to the contention raised by the Lenin Council for the respective parties, let us first discuss whether the prosecution has proved the death of the deceased to be homicidal or not. In this respect, apart from the inquest report, Exhibit 5, the evidence of PW1, Dr. Dr. Gaurachandra Jena is very relevant. He was the surgery specialist attached to Chandbali CSC, and on 23/11/2010, on police requisition, he conducted post-mortem examination over the dead body of the deceased and noticed as follows, quote कर देवे तापरे से जो opinion टा देइछि, nothing has been brought out in the cross-examination of PW1 to discard his evidence. Therefore, we are of the view that on the basis of the inquest report, the evidence of PW1, the post-mortem report, Exhibit 1, the Lenin trial court is quite justified in holding that the deceased met with a homicidal death. The case is based on circumstantial evidence. The two witnesses on which reliance has been placed by the Lenin trial court, main reliance has been placed, are PW9 and PW10. PW9 has not only stated about the demand of dowry, but also stated that after 20 to 25 days of marriage, the deceased informed him over phone about the torture made by her parents-in-law and sister-in-law, both physically and mentally, demanding dowry of cash of rupees 50,000. He further stated about the assurance given to the family members of the appellant to fulfill the demand after selling the paddy after harvesting. He stated that on the date of occurrence, after getting information over phone, when he along with others reached at the house of the appellant, they found the deceased was lying on a cot in a pool of blood, and she was dead, and she had sustained injury on the head, and there was profuse bleeding from her head. And the mother of the appellant was sitting by the side of the deceased, and she told that the appellant assaulted on the head of the deceased by means of a crowbar, as a result of which she died. Almost identical evidence has been adduced by PW10, the informant in the case, and elder brother of the deceased. However, in the cross-examination, it is stated by PW10 that police had given them 54 items after seizure, and accordingly the Jimanama was signed, and whatever they have received from the police as per Jimanama, those articles were given to the deceased out of love and affection. This statement naturally rules out that there was any demand at the time of marriage, or any article was presented or was given to the deceased on account of such demand. That is the exact reason why, that maybe the reason why the charge sheet was also not submitted under section 4 of DP Act, so also under 304B of the Indian Penal Code. PW 10 has stated that the appellant along with the deceased had been to their house once after marriage, and at that time the appellant and the deceased were living happily. Stop. The mediator of the marriage is one Hojua Naik, as per the evidence of the witnesses, including PW10. The said Hojua Naik is also a charge sheet witness, but he has not been examined during trial. Evidence of PW10 is that the mother of the appellant told to him that the appellant assaulted the deceased by means of a crowbar, for which the death took place, and thereafter he lost the FIR, is very relevant, in as much as when the FIR was lost, there is nothing in the FIR that about the mother of the appellant giving any such information to the informant that the appellant assaulted the deceased by means of a crowbar. Rather, in the FIR, it is mentioned that the mother-in-law husband bracket re, petitioner, sister-in-law, brother-in-law, uncle-in-law, and father-in-law's younger brother, all of them conjointly assaulted the deceased by means of crowbar, for which the death took place. At this stage, the decision relied upon by the Learned Counsel for the appellant in the case of Ram Kumar Pandey is relevant for consideration. In the said case, it has been held as follows, quote from paragraph number 9. If PW10 had got the earlier information which was received from the mother of the appellant that the appellant killed the deceased by assaulting her with a crowbar, then such aspect would have found place in the first information report. Not only the important aspect is missing from the first information report, but it has been confronted to PW10 and proved through the investigating officer bracket PW12 that in the 161 CRPC statement also PW10 has not stated any such thing regarding the information given by the mother of the appellant that the appellant assaulted to the deceased by means of crowbar. Stop. Mother of the appellant was also a charge sheet witness, and it appears from the trial court record that she was summoned to give evidence, but she was declined by the prosecution. Of course, no reason has been assigned in the memo as to why the witness was declined to be examined. But in absence of her evidence, the evidence given by PW9 and PW10 that they heard from the mother of the appellant that the appellant assaulted the deceased by means of a crowbar becomes a hearsay evidence, and it is not admissible under section 60 of the Evidence Act. It is not a case of paragon. It is not a case where only the appellant was staying with the deceased in the house in question. It appears from the evidence on record that the parents-in-law, the brother-in-law, the sister-in-law, and others were also staying in the house in question. And allegations were also leveled against them in the first information report. In such a scenario, when they have been excluded from the charge sheet and no cogent evidence has come by way of circumstantial evidence in this case against the appellant, it is very difficult to say that the principle which has been laid down by the Honorable Supreme Court in case of Sarath Brichyan Sarda regarding the acceptability of the circumstantial evidence to base a conviction, the Panchashil principle is satisfied. The circumstances found in this case are not clinching and they do not form a complete chain. Even though a crowbar was seized at the instance of the appellant, as appears from the evidence of PW12, and the doctor has also stated that the injury noticed on the person of the deceased is possible by the crowbar, but the chemical examination report has also not been produced in this case, though the crowbar was sent for chemical analysis. And no reason has been assigned by the prosecution as to why the C report has not been produced. Therefore, the seizure of the crowbar and the opinion given by the doctor bracketary PW1 in absence of any other evidence is not sufficient to hold the appellant guilty under section 302 of the Indian Penal Code. Therefore, we are of the view that the prosecution has miserably failed to establish the charge under section 302 IPC against the appellant. Accordingly, the impugned judgment and order of conviction passed by the Lennon Trial Court is hereby set aside. The appellant is acquitted of the charge. He is now in jail custody.
Yes.
Since he is now in jail custody, he should be released forthwith if his detention is not required in any other case. The investigation of this case is not up to the mark, and the conduct of the prosecutor in declining material witnesses without assigning any reason in the memo is also not appreciated. If a vital witness is a charge sheet witness and he is summoned, then ordinarily it is expected that the prosecution is to examine such witness. And if after testing the witness, the prosecution thinks it proper to decline the witness, then reasons has to be assigned in the memo as to why the witness has been declined, so that the appellate court would be in a position to know that why a material witness has been examined, has been declined. In a case of this nature, when so many exhibits were sent for chemical examination, it was the utmost duty of the investigating officer to obtain the C report while filing the charge sheet. And if it has not been done while filing the charge sheet, the London public prosecutor, so also the London trial court should have taken steps in ensuring that the C report is produced from the concerned forensic science laboratory. I would paraphrase. Before parting with the case, put a note of appreciation on Ms. Nando as well as Mr. Naik. You have been engaged as the amicus curiae.
Right.
So 7,500 is to be paid to Ms. Nanda as she has discharged her duty, and the release order is to be prepared for it.
I want to make an internal item for 13. Order number 8, order dated 13/1/2025. It was directed that detention period may be called for. Item number 13. Order dated
Please
13.
see Mr. Naik on question the detention, the period of detention report for the.
And tomorrow my matters will be taken up next day and any accommodation.
Which one?
After 17 item 70 JCR.
ତୁମର କଣ ହବ ଆଜିଠୁ?
କାଲି କଣ ହବ କି ଜାଣିନୁ ଆମେ, କିନ୍ତୁ ବଟ୍ ଗୋଟେ ମ୍ୟାଟର ଆମକୁ ଦରକାର, ତେଣୁ ରେଡି ହେଇଯାଆନ୍ତୁ।